Thank you, thank you. Yo, that's lit. That made me feel good. Boy, I'm in the mood now. What? For real. Something that I'm wanting to get into today is again, the irreparable harm and going into the depths of that. One thing real quick, and then I'm gonna let Brandon kind of speak on it because he was touching base really good last night on this when we were speaking about it. But yesterday we had two of our Operation Wisedome members go to court. One had an evidentiary hearing, the other had a jurisdictional hearing. My boy Hayden, who had his evidentiary hearing 4 months ago, reached out to me. Didn't know nothing, never even been into court before ever in his life. Had an attorney, I think this was his first DUI. I don't think it's not a legit DUI, but the aspect is he had no experience in court whatsoever, nothing, didn't study, nothing. He had an attorney, he paid this attorney $5,000. The attorney claimed to work 55 hours and all he had filed was a motion to the DMV. Not even to the court, y'all, so like to the DMV is pretty bad. Didn't get no discovery or anything, and at that point when he first came to me, it was, I think their offer was just like a settlement to kind of negotiate, right? There was just plea agreement. And he was nervous about that because, of course, he don't want to have to go through all that. He's losing his license, everything like that. So when he comes in, he was very skeptical, very nervous, wouldn't believe anything I was saying, like straight up, wouldn't believe me. He was just skeptical all the way. And he came in, kept listening, got some other validation from some other people. And as he continued to learn and develop and go through procedure and process, he built himself up so well that he's running the court, y'all. Like literally running the court all on his own after dropping the attorney. Now, he lost $5,000 on the attorney, unfortunately. But the aspect is that we go from a plea agreement with the attorney after paying $5,000 to him getting in there, defending himself, and then them speaking on, well, we're just going to drop it down to a reckless driving, right? Well, when he didn't want to accept that reckless, they again started initiating, well, we're just going to move forward then. You think you're bad? You think you're good? You think you got what it takes? We're going to test your ass. And they did. So as they come across testing him, he's nervous. Ain't no lie. Ain't no cap about that. My boy freaking out, shaking, all over the place. We calm him down. We empower him by letting him know who he is and how much power he truly has. So as we're going through this whole process, which what you'll notice, and others will tell you in here as they come up and speak maybe about it if they do, but we go from an aspect of not knowing who we are to who we are and having full power and retaining that power and instilling it to where others listen because the energy is being put forth. And this is not in a combative way, right? It's kind of how like, if you ever, know about sovereign citizens, you've heard about what sovereign citizens been doing over the past 6 years. They fight the police, right? Fuck the police. Break these goddamn windows. Fuck it, right? That's the mode, that's the way. But that hasn't worked. It hasn't worked. The division, us against them, has not worked. It's not going to work. So everything that I've been doing has been a unification of bringing us together. So as we've been brought together, Hayden yesterday had this evidentiary hearing. It was 2.5 hours. He deposed the cop for a full hour. And the judge comes out and says, you know what? Everything from this point forward needs to be suppressed. They're trying to bring everything in. But Hayden was able to get the judge yesterday on the record to say everything must be dismissed from the point of the stop. Would that ever been applicable if he wouldn't have been able to teach himself with everybody else in our group? No. We support each other very heavily. I want all of you right now to go look in your email from me and join Operation Wisedome through the Discord. Everybody gets it for free, okay? I want y'all to join. Brandon, you want to go ahead and speak a couple words on that? Just Operation Wisedome, which some of the things you were saying last night. They were very empowering.
Yeah, so hi guys. Good morning.
Wait. We don't say good morning.
Grand Rising.
Yeah, we don't mourn a damn thing. Do you mourn anything? I'm not mourning, well, not now.
Happy pickle.
There's a time for that, but right now we're rising with greatness, all right? Let's go.
Hey, I'm learning too, So, so I was there last night. I only got about 2 hours of sleep yesterday, so I was kind of dying. I got back, I was like, oh man, this is, oh boy. I got a little more sleep today, feeling better. I'll probably start screaming at some point. You guys can be excited about that. He had this dude on the iPad or whatever it was, and I thought it was amazing because he's there and I was laughing. He looks like a guy out of Office Space, and he has this tie out, and he's got a beer in his hand, and he looks like he just came back from fucking war, right? And it was the funniest thing in the world. And he's like, yeah, I did 2.5 hours in a hearing, and I'm like, every time I hear I was in a hearing, I'm always like, God damn it. Nobody ever gives me a fucking hearing, man. Never. I'll never do it. Gets me so mad. And then I see this guy looking like fucking, what's his face, the main character from Office Space with this shit, this beer, and he's like, yeah, I had a hearing and I deposed this cop for an hour, and I'm like, damn. I'm about ready to go bust in my own fucking windows, bro. I swear to God. And he's just like, yeah, and he was just like totally, coming down off the high of being so fucking terrified and so fucking excited. And I was just blown away because this guy's how new to this?
Say that again?
How new is he to this?
Not even, I guess, 3 months for Hayden?
Yeah, 3 months. He's like slamming this fucking cop through a deposition for a fucking hour of questions in a courtroom in a 2.5 hour proceeding. I was just like, it just blew me away because I've just never seen anything like that. We don't even see anything like that really in our group, in our private group. Joey's in there. I mean, we don't see a whole lot of, well, there's some criminal stuff in our private group, but it's mainly civil, but still, it just shocked me, And I think for a lot of people who have gone through criminal stuff, I mean, another thing is too, is you never know what's gonna happen. You can get pulled over in a week or whatever for reckless driving or God knows what, and then bang, you're in it, you know what I mean? So, I just thought it was amazing that a guy who's been doing this shit for 3 months was able to fucking pop that. I mean, that just never happened. It's just in the whole history of everything. I just don't think anything like that's ever fucking happened. So it just shows that, you can learn this stuff pretty rapidly. You can apply it pretty rapidly. I know yesterday when we were doing the surveys, a lot of people are kind of still pretty new. A lot of you guys are wanting to take action, but you're still kind of, you got your finger on the trigger, but you haven't really pulled it all the way back, So I thought I'd talk about that a little bit. I mean, Cam wanted me to talk about that a little bit, so there you go. And it's just amazing how fast we can get people up and off the ground. And it just shocked the hell out of me, so that's it. Yeah.
Thank you, Brandon. Thank you, bro. Yeah, it was really good. What I wanted to say, you ready? Can everybody give Hayden a round of applause real quick? Is that all right? Yeah, most definitely. Yeah, it's like I told him last night, bro. Like, I'm so proud of you, and I love this event. Don't get me wrong, but yesterday Hayden was the highlight of my day. I'm just gonna be honest with you, because all the time I put into people to see it actually flourish and manifest and become real, there's no greater happiness than that. When you see somebody in pain and sorrow and hurt, and to give that empowerment of knowledge to where they're flourishing, that is like the most wonderful thing, and I'm so thankful. So what we're gonna go over is irreparable harm, okay? Irreparable harm is a big deal. It is my baby, okay? It's injunction. It's stopping the damn courts, all right? I know we talk about a lot of the private processes and things like that, and people always want a silver bullet. Oh, we're just gonna file this one paperwork and everything's gonna be taken care of. It don't fucking work like that, 10 straight up, okay? There's a process. I go through the process, but I go through it very deeply so that you know what you need to do. So at its heart, the doctrine of irreparable harm stands as more than a technical standard for granting injunctions. But let's actually just take one step back. Let's look up what is irreparable harm. Irreparable harm is a legal term that refers to harm or injury that cannot be adequately compensated or remedied by any monetary awards or damages that may be awarded later. Irreparable harm is a necessary requirement for a court to grant a preliminary injunction in conjunction with a temporary restraining order. Does anybody here ever used injunctions? One time? What'd you use it for? Okay, to keep them from taking a vehicle. Did you know you can actually use a TRO against any agency or corporation? That includes governmental agencies and corporations. Did you know that? Yep, sure can. Thanks, Brandon. Appreciate you, brother. The movement, you all, or party seeking an injunction usually has to prove that they will suffer irreparable harm if the injunction is not granted. Is not granted. This is because the purpose of an injunction is to prevent further harm, right? Before it actually occurs. And once harm has occurred, it may be too late to adequately compensate the injured party. Now, some examples of that, where are we at? Deprivation of constitutional rights. Deprivation of constitutional rights. Under Title 18, Section 242, the deprivation of rights under color of law. Everybody knows what color of law is, right? Can somebody give me the definition of colorable law? Do you know? Okay, here you go. What's up?
It's like when people think some bullshit is legal when it's actually just been generally accepted by a bunch of normies and they kind of validate the nonsense.
Straight up. The normies. I love it. Perfect. We're going to get a little bit more legalese on you. Whoever under any law, statute, ordinance, regulation, custom, willfully subjects any person in any state, territory, commonwealth, possession, or district to the deprivation of any rights, privileges, or immunities secured or protected by the Constitution or laws of the United States, or to different punishments, pains, penalties, on account of such person being an alien or by any of whatever the case may be. These are deprivations of your rights, secured liberties, sacred liberties, creator-endowed rights. We're not going to take a deprivation of rights under the color of law, that facade. It's not real law. It's not real law. It's a statute. It's a code. It's a policy. It has no precedent over you unless, what? Perfectly said. The exact word. Consent. Consent of the governed, right? Everything is based on contract. You have to give up something to receive something. I'm not giving up my rights to receive a privilege. I don't need it. I don't need it. This is where we get into the irreparable harm and injunction aspect. And as you'll see, deprivation of constitutional rights, depriving someone of their constitutional rights, such as the right to free speech, the right to locomotion, the right to self-govern. You have a right to govern yourself. If someone else is trying to govern you, you've lost that right. And that is a violation of your creator-endowed rights. If you're getting deprived of any of your rights, this causes irreparable harm that cannot be fully compensated. We have life, liberty, and the pursuit of what, everybody? Happiness. Say it again. Life, liberty, and the what? Okay, now we're going to say it all together, all three. Y'all ready? Life, liberty, and the pursuit of happiness. If any of those things gets violated, it's irreparable harm. Your happiness gets violated, it's irreparable harm. Now do you see the depths of this? If you've never harmed a single person, if your happiness is violated, irreparable harm, send it up. We ain't fucking around with these little courts no more, bro. I ain't got no power over me. You're an administrator. Administrator. And let's just show you how much of an administrator they really are. Y'all think judges got power? They're really not even judges. You're over here calling them a judge. They ain't even a judge. It's crazy. Now, do we all know, what is a police department? Can anybody tell me? It's an agency. Is it also a corporation? Okay. It is most definitely a window-breaking facility. It is an irreparable harm factory, if we're getting honest with you. It's pretty bad. So judges who become involved in the enforcement of mere statutes, colorable law, we just went over that, right? Colorable law, it's a facade. Whether it's civil, criminal in nature, and otherwise being that quasi-criminal, those traffic tickets, act as mere clerks of the involved agency. Holy shit. You're telling me you're a fucking clerk? You're the highest clerk of this corporation. That's it. Their supposed court becoming thus a court of limited jurisdiction as a mere extension of the involved agency, corporation, police department. They're nothing but an extension. mere superior reviewing purposes. That's all you fuckers got? Really? Damn, okay. When acting to enforce a statute, the judge of the municipal court is acting as an administrative officer and not as a judicial capacity, or not in a judicial capacity. Courts in administrating or enforcing statutes do not act judicially, but merely administerially. They're administrations. That's it. That's all they are. So do they truly have power over you and I? No. Unless what? Consent. Why are you consenting to be governed? Why are you consenting to be told what to do? Can't you do it yourself? Can you do it yourself? Yes. No, it don't sound, y'all weak. Can you do it yourself? Yes. Fuck yeah, I love it. Oh! Okay. Every consent involves a submission. But it, by no means, follows that a mere submission involves consent. Uh-oh. Uh-oh. So if I'm submitting after you done, boy, you don't do what I say, you're going to get arrested. It's not necessarily consent, it's under threat and duress. Coercion. Can't do that. We're going to get you for that, boy. For real, for real. Wanted to show y'all that on the judges real quick. Let's see. You have to hit me up and I'll give it to you. That's why you want to be in the Discord. That's why you want to be in Operation Wisedome. Because you literally can ask, not only me, but pretty much anybody in there, and they're going to make sure to get you the right information. It's what we do for each other. Why? Because I am you and we are us, and we are all a part of the great I am. You got that? I want y'all to say it. I am you. I am you. We are us. We are us. All a part of the great I am. All a part of the great I am. Straight up. It's for real. It is a reflective statement on the fragility and preciousness of certain rights and conditions, realities that no monetary award or belated apology can ever truly restore once lost. By insisting that courts intervene before damage becomes irreversible, irreparable harm serves as a mighty shield for the bedrock values of our self-governing republic. It's like we forgot that. It's like we literally forgot that. Yesterday, when I was speaking on the aspects of that 1940 joint resolution, some people don't agree with me, and that's okay. We ain't got to agree on everything, but what I will say is this 1940 joint resolution has given me a different perspective, if I can get this big enough for y'all, has given me a different perspective on how I need to look at things and how maybe we have looked too deep into definitions to really understand or look and figure out what was going on in the context of that time period, okay? Let's see, so if we zoom this in. So this joint resolution, as I was talking to y'all yesterday, authorizing the President of the United States to proclaim, I am, number one. The first two, I am an American Citizenship Day for the recognition, observance, and commemoration of American citizenship. Now, when I hear sovereign citizen, what I hear is free American. Because as Americans, we have a duty, right? We have a duty to morally look out for each and every one of us. We the people on that hat, right? That is the I am. Whereas some 2 million young men and women in the United States each year reach the age of 21 years. There goes that 3 again, the Trinity. And where it is desirable, that the sovereign citizens of our nation be prepared for the responsibility and impressed with the significance of their status in our self-governing republic. What other context do you need? Literally, how powerful is that? That they sit here and diminish the sovereign citizen term, yet the sovereign citizen term is shown that we are impressed with the most significance of the status in our self-governing republic. Not a democracy, not a fucking republic. Well, I guess it is a republic, but it's self-governing. Big difference. Big difference. So in doing so, it echoes both constitutional design and biblical wisdom, protecting those facets of human existence, freedom of conscious, association, and individual dignity, whose injuries are far deeper than dollars can heal. Traditionally, legal redress has often taken the form of compensatory damages, financial sums awarded after an injury is proven. But financial remedies, while crucial in many civil disputes, falter gravely when encountering tangible or profound deprivations. If a municipality, for instance, shutters a congregation's place of worship under dubious regulations, no stack of money can recapture that loss of sense of unity and spiritual nourishment. You can't get it back. You can't gain back what you've lost. There's no amount of money that can give you back that happiness that you were supposed to have in that very moment, right? How are you supposed to get monetarily compensated for that? There's no type of money that can repair that, especially if you have some sort of PTSD or mental issues that you got to work through. Like, what kind of monetary value would you put on PTSD for the next 5 years? Could you even do that? Like, what would that cost? I don't know any amount of money that would actually fix 5 years of PTSD and harm. Because really, I don't value money like that. What I value is relationships, memories, times. All of those things are way more valuable than any kind of monetary thing that can be given to me. Wouldn't you agree? Yes, agree. Happiness. Experiences. Most important. So let me see here. We got spiritual dimensions of this. Now, why I think this irreparable harm is so important is because, we got freedom of religion. If you want to do religion, you can do that. But I'd rather just say freedom of belief, freedom of faith as you choose. So if you have that freedom of choice to believe as you believe, and you believe that you are the highest of authority and that nobody can come and take that away from you, and yet there's still some people that would like to do that, that's irreparable harm. Spiritual dimensions of what cannot be replaced. The intangible losses that irreparable harm addresses, such as spiritual communion, familial unity, personal dignity, or even free expression, right to locomotion, hold a central place in the divine scheme because you are divine. These gifts often transcend a purely economic valuation. The psalmist, for instance, proclaims that a single day in the courts of the Lord is better than 1,000 elsewhere, implying that spiritual blessings found in communion with God are unparalleled by any worldly compensation. Yes, sir, I agree. Most definitely. Wouldn't you? If law fails to act in time and a church's faithful gathering is stifled or a person's cherished moral stance is crushed, the vacuum left behind is greater than any damage check can mend. Now, what I want to show y'all is some aspects of, let me see here, if I do. Does anybody know about that jurisdiction aspect? Do y'all challenge jurisdiction? Anybody got any court cases they're dealing with right now? Like criminal? Are they criminal, civil, or what? Come on, yell it out. Civil? Civil? Any criminal? What about quasi-criminal? Quasi, like tickets and shit? That's quasi. See if I can get this a little bigger. Sorry, I yelled a little bit too loud yesterday and lost my voice, so bear with me. A distinction must be here, and this is a quote, by the way. A distinction must be here observed between excess of jurisdiction and the clear absence of all jurisdiction over the subject matter. Any authority exercised is usurped authority, and for the exercise of such authority, when the want of jurisdiction is known to the judge, no excuse is permissible. It's all a want of jurisdiction. It's want. They operate off presumptions of want of jurisdiction. Not that they truly got it, but the problem is that we go into courts and we don't invoke what we need to invoke. See, what I've ended up figuring out is there are a shitload of doctrines that we're just letting fly by. Literally, we just let these doctrines fly by. And we never invoke them. And if you don't invoke them, they're going to railroad you and you ain't going to get nowhere. So we invoke things such as the rule of lenity. Does anybody know what that is? Rule of lenity. Lenity. Anybody? Come on now. Somebody knows. What about you, big boy?
I'm blanking.
Okay, that's all right. He's blinking. He's just blanked out. What's up in the back? Come on now. Get him a mic, please. He's in the very back. Anybody? That's all right. We got you a mic somewhere. Brandon's going to run you back one. Look at him. Yeah, that good old Rule of lenity. Come on now, give me some.
I don't know if I'll say this quite right, but it's limiting and making certain information not be able to be spoken of or brought forth as evidence that has been...
Okay, wait. You said limiting. I said lenity.
Yeah, no, I understand that. That
Okay.
Am I wrong?
Yeah,
Okay, sorry.
it's okay. You're
The
wrong.
rule of lenity.
No, be straight up with you, bro. You're all
He's
the way
got the
right.
balls to stand up and fucking say it, though.
Yeah, he does. Everybody else was just sitting down quiet. We got one more hand up back there. One more hand, Brandon. One
Oh,
more
shit.
hand.
It's the idea that when you're representing or presenting yourself, you don't have to know all the rules that a bar card would know.
Nope, that's not it either. But y'all are doing good on trying, and I really appreciate that. There's two more hands up.
Couple men with the big balls. Any more big balls,
Yeah,
people?
I like the big balls.
Here we go. We got a big baller over here.
I'm telling you now. Y'all are doing great. I really do appreciate this. I like it more interactive, so if y'all can keep doing that, that'd be great.
Am I more like a Maury or am I more like a Jerry Springer?
Jerry for sure. Maury doesn't walk around.
Jerry!
Bring it back. Yeah, that's cool. I love it.
We're not going to fight now, are we? All right. I would say that it's where those who are going in without any bar card attorneys or whatnot, that the judge is to interpret any kind of law or criminal law to the best of the ability that helps the defendant.
That's very good. That's very good. Very close, too.
Oh, shit.
Very close. Yes. So what ends up going on, I'll give you a quick example. So like my boy Luis, he was one of our first guys that came into Operation Wisedome. We kind of blew him up really big. He was sitting at a gas station with his family, had his car on the trailer. They're parked. Sheriff comes up behind him, starts harassing him. He, give me your ID, blah, 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 blah. He's got plates on, private plates on that he's made himself. We call them notice placards because we're putting them on notice. And they give him a fraud charge. Wasn't it fraud or? Yeah, fraudulent. It was like deep. It was like fraud type. Yeah, it was felony. And yeah, straight up, they gave him a felony fraudulent plate type vibe thing. And when we started looking into the actual language of the statute in and of itself, it was very specific that it must be a document. Well, let's look up what a document is. It has to be paper, right? Has to be somewhat trying to replicate an actual plate itself. Washington, all those other aspects. So when we're looking into the rule of lenity as a doctrine, if any of the statute, or if the prosecution tries to go outside of the statute, we would invoke this rule of lenity to say you can't do that. You have to stay within the lines and boundaries of what the legislation says. If you're not staying within those boundaries, then it's null and void. We get it dropped. That's one doctrine. Anybody know about the fruit of the poisonous tree doctrine? Yeah, y'all heard about that? Show of hands, who's ever used that? Oh, hands went down quick. It went up, but they went down quick. So, but you know about it, right? No or yes? Okay, so fruit of the poisonous tree is great because we just utilized it yesterday for Hayden's situation. But that's pretty much like your suppression, right? You're getting things suppressed based on the aspect that, let's say like cop comes and demands you about the vehicle, some shit like that, right? Or, let's just say something like that. And they do it illegally. Well, if they're violating your sacred endowed liberties, that is more important than the statute in and of itself. So instead of arguing the facts of what they're trying to claim against you, why not just come over here and say, well, my sacred liberties were violated first and get everything else dropped? It's like my people come in and they're like, oh, I want to argue the fact that I know I have the right to drive. You know, like I learned it. I know. I've got case law. But that's not your argument. Your argument should be the aspect that you should have never been pulled out of the car. You should have never been given tickets. You should have never been spoken to the way you were spoken to. You should have never had threats being thrown at you as though you were lower or inferior, right? Sonny, where are you at? You in the back? Give that boy a mic, please. Please.
Jerry. Are we gonna do a little police brutality here, bro?
Fuck those windows. Hey, Sonny, what police department do you work with?
Tampa Police Department.
You gotta speak up.
Tampa Police Department.
How long you been with Tampa Police Department?
A long time.
Long time?
Total of 19 years.
19 years. Boy, you're a career criminal.
Guilty.
I know this may be a little bit personal, and I haven't asked you this before, but you've probably pulled out quite a few people out of the car, right?
Yes.
Was
No
it
broken windows, though.
No broken windows?
No.
Damn. Well, you're not good enough. Get the mic back. No, I'm joking. When do you normally ask people out of the car?
If I know they're going to jail.
Nothing else? You've already made the decision. Okay. Is it normally based on just a hunch, or do you have to have some things that are required before you can ask people out of the car?
Probable cause.
Okay, good. Probable cause of what?
That a crime has been committed.
Oh my God, I love you, bro. You're a good cop. Okay, thank you. Brandon, you can get that from me for right now. So what I want to come into is this actual document right here was filed on 3/25/25. This is actually an order from a judge on a case out in West Virginia. Has anybody here heard of the civil rights attorney on YouTube, John? Huge channel. He's a great guy, right? What does he say? Freedom is scary, deal with it? Lovely slogan. I love it. So this case came out, and this was in relation to a guy flashing his lights, okay, to let oncoming passengers know that, hey, they're over here shooting their speed camera. You know what I'm saying? Watch out. He gets pulled over for that. Free speech. What I want to show you, though, let me see if I got anything else highlighted. Yep, I do. I got to get to these first ones first. Oh, is it this one? Okay. Wait, is there any? Oh, yep. Unconstitutionally. I think we're right here, and that should be it. So what we're showing here is the order from the judge. The plaintiff contends that Deputy Ellison stated he initiated the stop because the plaintiff was signaling other drivers of the presence of another officer. Damn, that justifies getting pulled over now? There does not appear to be a law in West Virginia that criminalizes such behavior. So the stop is what? Wait. The stop is what? Unlawful, illegal. Taking the facts as the court must, in light most favorable to the plaintiff, Deputy Ellison allegedly initiated the stop without reasonable suspicion. Such stop would violate the Fourth Amendment. Fourth Amendment right there from the stop is done. That's a violation. So again, what is more important, the statute or the violation that has occurred against us? That's every damn traffic stop. Especially if they cannot prove the aspect of you operating on the roads in a commercial capacity. Everything's about commercial. Every fucking thing is about commercial. If you are not traveling on these roads, watch this one. Y'all gonna trip out. Y'all gonna be like, what the fuck, Cameron? It's sitting right up under our noses and nobody even realizes it at all. Okay, so we're getting definitions all throughout Washington and stuff. Public highway, every highway, city street. We're getting all these definitions of county road, city street, highway. Let's see. And if I come down. All right. Franklin County Code in Washington. Road, public road means a road, whether improved or unimproved, held in public ownership and intended to be open as a matter of right for public vehicular travel. Open as a matter of right for public vehicular travel. Have y'all ever seen something more like, what? Are you kidding me? So we got it in almost every county in Washington, open as a matter of right for public vehicular travel, all over the place. Now that's county codes. Let's look at some municipals. I mean, I can go on all day, y'all. Municipals now. Street means every way, lane, road, street, boulevard, and every way or place in the city open as a matter of right for public vehicular travel. Right to travel. Open and free. Why? Because you own it. So actually what's happening is that every time these law enforcement, not talking about you, Sonny, necessarily, but the ones that are egregiously out here violating us, they're actually out here violating their own municipal codes. They're violating their own municipal code by presumption. Rebut that shit. I got a PDF on my website you can get for $15.36 if you want to grab that. It rebuts all 12. Not really, I'll give it to y'all for free. Okay. Critics of injunctive measures sometimes argue that the economy of communal projects might stall under the weight preemptive court orders. Yet such arguments underestimate the broader social cost when intangible rights are undermined. Indeed, in a self-governing society, the public good is not advanced by trampling on fundamental liberties. A city that, for instance, demolishes a historic spiritual retreat center for a profitable development cannot, by paying monetary damages, later restore the retreat's decades of sacred meaning and communal bond. Allowing the bulldozers to roll over that heritage would exact a cultural and spiritual toll well beyond material sums. Irreparable harm analysis aims to preserve that which stands irreplaceable, ensuring that commerce or administrative convenience does not bind us to priceless elements of human experience. By compelling courts to weigh whether the threatened damage touches on these experiences, by compelling courts to weigh whether the threatened damage touches on these non-replicable dimensions, the doctrine preserves a crucial check. In a republic aspiring to reflect biblical compassion and constitutional fairness, it is better to temporarily halt a question. You okay? Okay, just want to make sure. Do we need to get you something to drink? You got some tea? Okay. Questionable project than to allow permanent scarring of individuals' rights or cherished properties. Now, what I think is very important is the moral compass that we have to start doing is bringing ourselves together in unity, both on the law enforcement side and our side, and utilize these courts to actually do what they're supposed to do. When we file these, let's actually look at an injunction real quick. This is something we developed in the group. This is an injunction. And I want to show y'all how they work, okay? They're very powerful. This is a plaintiff's verified motion for a temporary restraining order and a preliminary injunction. This one's just a template. We didn't fill in all the names, but you get what's going on. Comes now plaintiff Cameron James Wilson in propria persona pursuant to the Oregon Rule of Civil Procedure, along with the Constitution of the State of Oregon and the Constitution of the United States, to respectfully move this honorable court for a temporary restraining order and after hearing a preliminary injunction restraining Joseph Miller from continuing or initiating any penal, administrative, it really should be the law enforcement agency. So wherever you're seeing Joseph Miller, it's the law enforcement agency. From continuing or initiating any penal, administrative, or enforcement measures arising from the alleged events described below, absence of verified complainant or demonstrable corpus delicti. Do y'all know what corpus delicti is? Anybody? Oh, we got a hand up. We need a mic. Jerry? If you don't mind. Throw that hand back up. Come on now. I know you know. Oh, I know he knows.
Corpus delicti, corpus being body, and of the case, delicti, I believe that the corpus delicti is the body of the case.
Perfectly said. You said it perfect. There must be a body. There must be an essence of the crime in and of itself. If there ain't a verified complainant that's got a signature with a sworn affidavit, it cannot stand. Why is that? The law enforcement agency works for the corporation. They are not harmed. They have to have some corpus delicti. It's kind of like mens reis and actus rea. Does anybody know what that means? Okay. Microphone to Matthew, please.
Mens rea is guilty intent.
Okay.
And then actus reus is like the criminal or guilty act in itself.
Yes. There must be a thought and an action for there to be a body of crime. It can't just be like, oh, I accidentally did this and I didn't have intentional thoughts to do it in the first place, right? There has to be both elements met for there to be a crime. That plus there's got to be someone that's harmed. This request seeks to protect the plaintiff from imminent irreparable harm, to enforce Oregon's statutory and constitutional mandates, and to ensure that fundamental civil rights remain secure. Now, I know Brandon's like, fuck those civil rights and the 14th Amendment, fucking bastards. But hey, man, it's a double-edged sword. I'm using that shit. In all of my civil cases and my complaints, I'm using the 14th Amendment. And I'm going to get paid out that shit. I'm going to get paid off that shit. Straight up. You use it too, huh, Joey? Let's get it. Let's get it.
We're going to have our own court case right here live about
let's
the
do it.
14th Amendment. I'm going to win the fuck out of that thing,
Let's
by
do
the
it.
way.
Let's do it. So, the context of the encounter, there was no public travel, no traffic stop. On or about December the 8th of 2024, this is the actual situation as well. Approximately 12:40 a.m., plaintiff lawfully parked in a private parking lot and thereafter left it locked. Plaintiff was not driving on any public roadway nor subject to a traffic stop. Defendant Joseph Miller purportedly, okay, we'll just act like that. Purportedly a peace officer through official capacity, uncertain, approached plaintiff on foot, absent any flashing lights or lawful stop, initiating an encounter, bereft of probable cause. No crime had been committed. He's literally in a parking lot. He starts walking. He acts like he parks his car. The cops chase after him. There's no crime. And as he's walking away, they're tasing him. And the lady's literally like, why won't you talk to me? It's the most craziest thing in the world. And they bring charges against him on private property as well. Filming and a refusal to provide identification, claim of DUI. The plaintiff exercised a constitutional right to record law enforcement, obtaining defendant's name and the badge number, the physical assault and taser development or deployment without legal justification, an unwarranted vehicle searched, a coerced blood draw under duress, pending charges and court dates for administrative threats, right? Going through all of that. Now, to grant an injunction under the Oregon Rules of Civil Procedure 79, the court typically considers whether plaintiff faces imminent irreparable harm if relief is denied. There's reasonable likelihood of success on the merits. The balance of equities. Ooh, that's big. And hardship favors granting relief. A TRO and preliminary injunction serves the public interest. Defendant's non-compliance with an injunctive order may render him or other involved officers liable under 42 U.S.C. Section 1983. Does anybody here know what this right here was before it became 42 U.S.C. Section 1983? Anybody? Joey? Do you know?
No, but I want to talk about that.
Me too.
No? Something else. Anybody? What you got, Papa?
I learned it from you yesterday.
What is it?
The Ku Klux Klan Act.
1871 Ku Klux Klan Act. It's pretty deep. That means all of us out here bringing in claims under civil rights got those civil rights because all those black people was out there getting hanged. It's pretty extreme, but it's the truth. For civil rights deprivations and criminally prosecute under 18 U.S.C. 241 and 242 for the willful rights violations under what? What? Color of law. It ain't real, y'all. It's a facade. It's not law. It's a statute. It's a policy. It's an ordinance. And there must be consent for that policy, code, and ordinance to apply. That's how it goes. Let me see what else we got here. So, first of all, intangible every day. Okay, yep. Every day that plaintiff stands under threatened arrest, forced appearances, potential license suspension, or other further intimidation by defendant for a non-existent DUI offense is an irreparable injury. Right or wrong? If I got to constantly sit here and show up and deal with this bullshit that is taking away my happiness, that's irreparable harm. Emotional distress, physical fear, spiritual affront, compelled medical procedures cannot be atoned for by any later monetary sum. There's nothing that you can give me in money to fix the things that you've already damaged. It's done. This intangible harm is precisely what the TROs and preliminary injunctions exist to forestall. Of course, we go into the reasons on why there's no verified complaint in nor corpus delicti. The balance of equities favors the injunction, going into that a little bit deeper. The public interest requires immediate relief. Why would that be? Because there's nobody harmed. If there's nobody harmed, the public don't want to see you harmed. Do we want to see someone harmed that hasn't harmed anybody? What kind of sense does that make? Other than these greedy-ass corporations taking advantage of people's ignorance. And that's why the system exists. It's to keep each and every one of us a slave so that we don't stand up and self-govern. So what we do is we ask for our relief, right? We're essentially asking for them to really bring forth a sworn affidavit. Really bring someone who bring the corpus delicti and show us that you have it. If you don't have it, it must be eliminated. And we're asking the court through an ex parte emergency hearing to grant that until they can give the elements to then bring any charges against us, okay? So this was just a little basic injunction here I wanted to show y'all, just real quick. And that's how we do it. Wow, y'all are really... Now, something else I wanted to show y'all. Have y'all... Who has already joined the Discord? Are y'all in the Discord? Oh, shit. Really? That's cool. The rest of y'all need to hurry up and get in there. What I wanted to show is right now... Oh. Hey, everybody in Discord. I wanted to say hi to y'all real quick. Let me see if I can turn this around. Can everybody just wave to all of the Discord members real quick? Y'all say hello. I just wanted to let y'all know, all my Operation Wisedome members, I love y'all. I just wanted to say hello. I hope y'all are having a great day. As y'all are talking, I'll talk to y'all later. I wanted to say hello to them. But what's pretty cool is that we're always in here chit-chatting. We're always in here working. Wow, a lot of y'all did join. I haven't added all y'all yet. I'll add y'all in a little bit. Okay, so what we got going on here is I'm just wanting to see if I can show y'all a little bit of what we do. So you'll notice that we have voice chats over here. We have work and play. This is where we do all of our chit-chatting. There's almost 400 members in here now. So we do a lot of chit-chatting. We got the Trust Game series. I spoke with a couple of y'all this morning about the Trust Game. Tomorrow I'm actually going to send all of y'all the full Trust Game series, okay? It was gifted to me by one of our Operation Wisedome members. This trust package is insane. I mean, this doesn't even make sense on how I got this, but I'll just show y'all real quick. So let me see, I got Cam, I think it's in this one. And then we're gonna do, has anybody ever heard of the 0%? Yeah. Yeah? Who's heard of the 0%? Y'all raise y'all's hands. Okay, good, a couple of y'all, I like it. All right.
Just while that's loading up.
Yeah. Straight up.
He had a slide up there just a second ago, and you're going to see some fundamental differences between what we talk about. But there's so many similarities, and I keep hearing this from you guys, and this is the coolest thing for me too, is that what Cam's saying, his process and Joey's process, I'm getting confirmation and confidence that this is real because I see you two guys doing it. Now, we do not attack things from the same angles, but you'll see our love for the 14th and Brandon's hate for that. You know, there are some similarities. But the slide he just had, and I need to ask him this, because I want this to come out in front of you guys, because I have lived the 18 codes. Have you got any pushback from a criminal standpoint where you're at, and the horse shit that they're going to deliver you, that you do not have a private right of action for 18 codes? Brandon's lived this.
Okay, in what manner?
When we filed in the 18 codes, so any of you guys that don't know, the 18 USC 242 mirrors 42 USC 1983. I use 42 USC 1983 because I saw it, and that's cool. It's the personal liability. So, and it's the one Sonny would chime in and say if his ass ever got sued, it was always a 42 USC 1983. Now, if the United States attorney was bringing claims against him, that's the governmental piece of it where they're going to say we had the right to bring criminal charges against Sonny because we got the big dicks and we're the ones that are the attorneys. You don't. You can't use that. So that's what What I'm asking, there's been pushback I've seen in the courts, and they always use that you have no private right of action for 18 codes. Because if you guys looked it up right now,
Oh, that's true.
United States Code
Yeah, that's true.
18 says you're not going to get anywhere. So my
Yeah, you
point-
can't use it.
my point with this is if you file that, don't take what he's giving you the groundwork, but don't file your complaints with that
Yes.
statute in there. It's going to get shot down
Correct.
right now.
Yep. 100%.
There's a few 18s. There's a few 18s like peonage, slavery. I think it's 1595. It has a special. It's 18 USC 1595. It's a special area that does give a few things a civil ability to bring them charges. But in Title 18, if there's no specific civil backdoor or whatever you want to call it, then yeah. So I had to learn that the hard way. That was the first like fucking 4 months of me doing this, so it was pretty awful.
And I would say always challenge that too, because I had a case, I won't get into it, but where they took a property from me, sold it, and didn't do what they're supposed to do, which is give me money, compensation. And they came in and they started using all of these you don't have private right of actions to silence me. And you guys should always look at every time they use that, and they'll use it every fucking time, and they'll usually cite case law. The case law is horseshit, 9 out of 9. And the horseshit with the private right of action, if they don't have that, they're putting that presumption on the record. And you keep hearing Cam saying it, you keep hearing Joey saying it. Those presumptions are real. So Mr. Kimbrough doesn't have a private right of action to challenge the municipality, is what they said to me when I'm defending my own property. You motherfuckers are trying to steal. So that's the key. When I went back version 2.0 and I looked, you've got to bring the evidence to the record that tells me that I don't have a private right of action. Let's start there. By you just saying it and me not rebutting it, guess what my dumbass did? I gave them the opportunity to use that and make that the law. Yeah, bro.
Jerry.
Y'all so stupid.
So we're doing something a little bit different. So what I did was in my memorandum of law, I referenced the 18 USC, but then I put in the 42 USC. I made it clear that I am not bringing something that I don't have a private right of action for. However, if the prosecuting attorney would like to do so, here are all of the things that you can follow through on. I am doing this as a private claim.
Yes, sir. I love it. Terminology is everything. The terminology is everything. Okay, let's get back into it.
Real quick, one more thing.
Yeah.
Wouldn't a private right of action be a jurisdictional issue? Is why it's not accepted?
Go ahead.
What was
I'll
the
let
last
him
part on
answer
that?
that one.
I didn't hear it.
Yeah, he was directed toward.
I think that you could go both ways on that. So if it's a private right of action where they're trying to throw out your claims, I would say, yeah, there's definitely a jurisdictional component. Now, if your entire case was brought for a different cause of action and now you're in a dick measuring contest, which it happens most of the time, I don't necessarily think it's jurisdictional as much as probably a procedural issue that you're trying to wade through there. They're going to do everything they can to try to throw you off. When they're spouting the private right of action, it's not necessarily the jurisdictional component they're going after. They're trying to get you out procedurally. So it's kind of one and the same. Well, people ask me about equity all the time. Fuck, that's like me talking Chinese. I have no idea what equity is, and that sounds kind of funny probably because you're looking at me as somebody probably I don't give a fuck about equity. I'm here to kick your ass and take all your money. I don't give a fuck about the equity. You own a farm with 10 chickens and 3 cows. I want what's in your bank account, So I look at the compensatory damage that I can bring, and the equity and all of that stuff. It's like talking foreign shit to me, man. Actually, Blue asked me that the other night about equity and why it's something I don't know. I haven't studied. So I'm going to be 100% honest with you, man. Maybe that's the way to go. But I've not seen anybody with equitable claims, and maybe so in Cam's stuff, when you're talking about criminal charges and stuff, and this is good for us to be able to chop this up as a group. I just haven't seen equity over on the other side of the fence. I don't even know what the fuck equity is. I know what Martians are, but I don't. Yeah, common law, is that what you're saying? Oh, I get that. Common law is God told me not to hurt you, and now I just said I want to take all your money. You know, so we got to look at what it is. Now, why am I wanting to take all your money? Because you're being an asshole to me, kind of thing. You know what I mean? So maybe that's the equity in the whole thing, and now maybe it's clicking for me. So, you know, God told me and you not to hurt each other, and here we are in court trying to hurt each other, kind of stuff. So you call it equity, I call it me kicking the shit out of you. So I don't know, whatever. But statutes are horse shit, but yet statutes are what we have to do to kill the argument. It'd be really hard for you, me, Cam, Brandon, anybody to go into court and talk about God's law, because they're going to look at us like we have three eyes, because every one of those motherfuckers are satanic criminals, if you ask me. So you look at just God's law, and if you have that as the whole basis, it's good to have it in there. I'm going to share something too, man. It's kind of funny if you look at the end of all of my complaints, this is kind of a hack that I did that I'm waiting to get busted for. So I'm going to tell you, and don't tell on me. And I saw this on Brandon's page the other day, is I'm a big believer in the Bible. I already said that. And here I am wearing a Masonic hat. I'm supposed to be satanic myself. But if you look at Luke 11:45 through 52, and then you look at Hosea 4:6 through 8, I love starting there with two of those. In the book of Luke, he's killing attorneys and Pharisees, he being Jesus, if you believe in him, whatever, it doesn't, we're still cool. But he's there and he's admonishing them 3 times. Woe to you, Pharisees. He's kicking the fucking shit out of them. He hates their guts, to be real honest with you. This is Joey's interpretation from the Midwest. But he's also the lawyers, i.e. the guys that were interpreting the law back then. They were called lawyers, a different version of what now, but they were interpreting the 5 books of the Torah. So they were helping the Pharisees pull off the early game that we're living with today. And what does he say after the woe is to me when the attorneys say, Master, do you admonish us as well? And he went on a fucking tirade. He said, your fathers were the ones that killed the prophets, and you motherfuckers are the ones that are taking the key of knowledge of where you yourself are not willing to take some of the burden. Doesn't that sound like a modern day attorney to you? He's kicking the shit out of your knowledge level, and he's not willing to help you in any capacity, God's law, in the word. And that's why there's no love there, man, between them and us, because of what they're trying to do and the knowledge level that you're wanting to gain. God's law starting there, let's not hurt each other kind of stuff. So if you go over to book of Hosea 4:6 through 8, what does it say there? My people will perish for lack of knowledge. It's kind of funny. What did Solomon, the richest man in the world, ask for? Wisdom, otherwise known as knowledge. So it's funny if you read the book and you truly study the stories, the horseshit that's coming at us right now, we call equity and all of that stuff, is great. It's a great place to start, but knowledge is it. And Cam's bringing you knowledge. I'm bringing you knowledge, at least our experiences. You're going to hear more and more about experiences from both of us, and it's our experiences. So that's all I wanted to say about that. The 18 U.S.C., I'm telling you from experience, if you take that into the court, you're going to get your face smashed in. And that's okay. Yeah, what's up, bro?
That's a lot, because you're trying to bring Admiralty jurisdiction
Yeah.
argument to a common law equity jurisdiction.
Yeah.
And they don't mix.
Yeah. Do you have any kind of cause numbers of?
Well,
of
what was he
anybody?
saying? Let everybody know,
he's
'cause we don't
saying
know.
that- yeah, so that's good. He's saying the reason why is because you're bringing Admiralty claims into an. It was at the common law claims into an Admiralty court. So I would love to. So here's where I want to increase my knowledge level. Anytime I hear that, and when I ask for a cause number, I'm not doing that to be an asshole. But guess what? I never get. You'll find out, and that's cool. And Joey at prosay.com, I truly want you to send that to me because I never have seen it. But I see a bunch of, not you, motherfuckers on the internet that say, hey, do this, do that, and you're a dumb fuck. And I'm telling you from my experience of what I'm doing, if I go in and start telling you Admiralty, common law, please slap me because I don't know. I'm truly saying something from a video I saw. I ask all the time, as Brandon knows, when people come at he and I both, and this happens every day of every week, with the latest, here's what I've seen or heard or whatever the fuck, and I ask for cause numbers, I've never one time, I've got one time from somebody that actually wanted to be a part of what we're doing, but for the most part, I don't see it. And I truly want to see what it is people think that's out there, but I've never seen anything that says, my Admiralty, you know, I don't know, but what I can read is what he's got up there on the screen right now, and I can see other cases. I can go look at Hill case, and I do. I can look at Rodriguez, and I do. And I study United States v. Palmer, I do. That's Fourth Circuit. I've done a lot of stuff out of there, but I don't see any of the other stuff. You're going to see that a lot too, by the way. You know, and I'm truly not picking on my man here. I'm just saying, just be careful. Even if I tell you something, man, use discernment. Why am I here? Maybe I'm one of those agents that you're in with this conspiracy. But maybe I'm here to throw all you guys off. I don't know. But I got receipts. You can look at the receipts and you can see that you're real stuff. Cam's got receipts, so his experiences are real too. So anyway, we're definitely going at things very, very similar, and it's cool for me to hear from several of you guys that's, hey, this is confirming for me that where I want to go, listening to you two morons talk about your experiences is giving me confidence. I love hearing that, if anything, man. I flew 1,500 miles to talk to you guys on my dime, and I'm here for 3 days to talk to you guys about whatever you want to do in your experience level. I'd love for you to call me and say, hey, I used what you said, like Cam's talking about. That gives him the biggest high. It gives me the biggest high whenever I take somebody through that process and they win. And it's all about winning for me. I've already told you that. I'm not sidestepping that. Fuck it. I want the W. So sorry.
Can I say one thing real quick before that? I want to
say something in conjunction with what was being discussed.
Go,
so
B.
if we could just
Right now.
Yeah. Stand up.
You got it, Brandon.
Sonny, come arrest this man.
I just want to speak on equity. Been doing a lot of study on that, and equity, and my knowledge is only coming across in a chancery court, which is why there's only 9 chancery courts in the United States remaining, right? So if you want to deal with equity, you got to get to a chancellor. Now, that's in my studies, that's why Delaware is the oldest chancery in the United States, and that's why all your Fortune 500 companies run out of Delaware, because they want to deal with equity, not admirability. The other aspect is when you go into a court to see the flag with fringe around it, you know you're on a ship, right? So when you see an admirability flag as you're coming into a court, you usually don't see those same things. Not to my knowledge, I've never been in a chancery court. There shouldn't be a fringe around that court when I'm dealing in equity. Now, getting to that level has been extremely hard. You know, to even find somebody to talk about equity in a chancery area, you've got to, $400 or $500 an hour, and then they're going to look at you kind of crazy, right? But still, in my studies, chancery deals with equity. Anything outside of that court, you're going to be dealing with, statutes, policy, procedures, just getting into the code, right? But equity should look at a case fair-handed, and then and be able to make a ruling on that with looking at the spirit of the law, not having to deal with, a procedure, right? You're dealing with somebody that gives you the ability to make your case, look at the spirit of the case, not the letter of the law. You're dealing with the spirit of the law. So that's why there's no chancery courts left. Texas doesn't have one. You got to get to Louisiana, Tennessee, Delaware is where I'm trying to go, right?
And I'll cover a lot of that on my when I talk today. We're going to be covering what happened to America, where to go, and then what it was replaced with in more detail than anyone has ever seen in their lives. But I have a question. Who all here has a Pacer account? Raise your hand. Pacer account. Pacer account. Pacer account. Pacer account. Okay, this is the problem. So everyone should have a Pacer account. I mean, you're not going to be able to get into a lot of state cases. You can find a lot of state cases just typing it into Google, but if you don't have a Pacer account and you've never filed anything, trust me, dude, I studied this shit for 2 years before I went into the courts. I thought I was going to be meeting green Martians on the Eastern Bloc. I thought that I'd be driving a 1974 Maverick, and I was going to pull in there with a cigar in my mouth. I pull up, there's 16 guys in black vests, and my throat was torn out, and every bone in my body was broken, and I was thrown on the side of the road and then set on fire, and then they drove over me while laughing, smoking a crack pipe. So I just want to be clear that I am the guy who's studied a lot of this stuff, as you know, and you go in there, and it's so different than anything you've been hearing for a year or two, and you wind up getting your teeth and your head and your skull smashed in so badly that most people never come back. They do it once, and they say, holy fuck, I can't believe I made it out alive. Because the stuff that they were learning before they went in there is so fucking different than anything that when they went in there, they think, God, I must be the dumbest son of a bitch walking the earth. I must be the dumbest son of a bitch walking the earth. I didn't feel that way because I already was one stupid fuck. What do I give a fuck? You know what I mean? But the thing is that it's if you don't have a Pacer account and you're not looking, I recap everything. So how many people know what recap is? Raise your hand. Recap. At least know what it is. You don't need an account. Oh my Lord, there's not that many hands. Okay. So on my website, you can go on, and I'm sure Cam probably has some recap links too. There you go. So recap is a way that you can access dockets that would normally cost money and you would need a Pacer account to access. You have a little. This is important. You guys should be writing this down. AKA, write this the fuck down. Write the fuck now. Recap is basically a little browser extension that goes into your. I'm not going to be going over any of this in mine, so I'm glad we're going over this. It's a little browser extension, and every time you're in your Pacer account and you download a docket item for 10 cents per page, it goes into Recap Forever, which is the free law project, and now anyone can access that docket item without a logon, without a login, without a username, for free. So when you have a community like Operation Wisedome, or if you guys make your own private little communities, someone can say, hey, I'm going to buy this docket item. It's a complaint for a case that's really interesting. You can recap it, and then all your buddies and all your friends can now access that same docket item for free. You don't need to send it to them.
Just like the one on the screen right now.
Yes. So there's a lot of people here that are new to this. There's a lot of people who want to file litigation. There's a lot of this kind of stuff, right? You guys got to realize you probably have no fucking clue what you're walking into. You're walking into a room with a bunch of pieces of shit that want to take aluminum baseball bats to every single fiber of your fucking body. Okay? That's the reality of the situation. And I thought magic words and magic letters and magic fucking coats and magic fucking jackets and magic fucking magic fucking symbols were going to help me, and they didn't. So I'm just letting you guys know the reality of the situation. If somebody would have told me that, maybe maybe I wouldn't have been fucking crying, looking at manga porn, trying to fucking, recover. You know what I mean? So, yeah, I just want to be clear. You guys, if you want to learn, you have to at least be looking at like recap dockets and stuff at the bare minimum. If you don't want to pay for Pacer. But you can go on my website, williamsandwilliamslawfirm.com, and you guys can go to current and previous litigation, and you can see everything Joey and I's done, and literally almost every single fucking docket item for every single fucking case is all recapped. So we've fucked up so many things. Like, for example, using Title 18 claims and getting fucked in the ass in multiple jurisdictions about it, and wasting months of our time. If you just spend 15, 20, 30 minutes and go into our recap links and look at all the docket items for free without even needing a login to fucking do it, you will save yourself a tremendous amount of heartache and pain and wanting to kill yourself. That's all. Same thing with, the UCC, obviously. I mean, my God, that's all I talk about. So you guys can see all the pain I've gone through on that, yeah. And basically, commercial code claims, Title 18 claims, and maybe a few other things, but still, it'll save you fucking many months of pain, I assure you.
All right, so check it out. We've been talking about irreparable harm. I'm more on the traveling versus driving aspect because I believe that's a really strong place to start off on and moving into full capacity and knowing. I feel like that's a first step, right? I'm going to empower myself on the right to locomotion. So let's check out a little bit on, at least in March 25th from this judge, on how that is applicable to you and how you really can utilize your rights. You're just kind of scared, right? You don't know any better. This judge, like we were speaking on earlier, unconstitutionally extending a stop by even a de minimis amount of time violates the Fourth Amendment. By failing to hand over an already written citation and prolonging the encounter, Deputy Ellison arguably made the stop longer than necessary to effectuate its purpose. Okay? If we keep going, now while it is true that an officer may order a suspect out of the car during a valid Terry stop, must be valid. Can't just be a Terry stop that you think you want to be valid. It must be valid. Such an order is only valid if the officer possesses an articulable and objectively reasonable belief that the suspect is potentially dangerous. Hey, Sonny, can you pull people out of the car if you don't see them as being dangerous? No. He can't. You never have to get out of your car, y'all. Literally. If you're not dangerous, if you don't possess weapons that they can clearly see, they can never ask you to get out of the car. I mean, excuse me, they can ask all the fuck they want, but you ain't gotta do it. Must be potentially dangerous, and you can find this at Law 463 U.S. at 1051, excuse me. Defendants cite nothing to suggest that between initiating the traffic stop, which again, it's really not even a valid traffic stop deeply if you're not transporting persons, property, or what? Goods. You must be transporting. What is transporting? Anybody know? You're getting paid. You're getting paid. Commerce. Anybody know what that driver definition is in the fourths? What's the first two words? I know my people know it. Wait.
One who is paid.
One employed. Very close. One employed. You must be employed to be a driver. It all comes back to, when you go back to it, it was all about chauffeur. That's why we can go across any state and any municipal code all throughout the United States to find the aspect that it says open as a matter of right for public vehicular travel. It cannot be more blatant than that. It's straightforward. So why are you out there giving up your right for a privilege? What else you doing that in life with? Taxes? Business? Relationships? Defendants cite nothing to suggest that between initiating the traffic stop and the plaintiff's laughter, literally, they get butthurt that bad that they can't even have someone laugh without them getting offended. It's pretty crazy. Ellison noticed anything that would suggest the encounter became dangerous to him. Without such justification, the act of ordering plaintiff out of the car is arguably unjustified. Let them do it. Sue and get paid. Knowledge is everything. Yeah, I'm going to have Quinton touch base on a little bit of his situation real quick. Come on up, Papa. So Quinton is one of our foundational members. He's been with us for a very long time in Operation Wisedome. How are you enjoying it?
Well, I'm here today because of it.
Yep.
I am presenting myself in court because of it. I was going to do it regardless, and then thanks to your video, Brandon and Cam's video, found Wisedome. We did the original video before Wisedome was a thing, and now we had a round of applause for Hayden earlier for something he did, and I'm next. Someone else is next. Like, it just keeps going. Like,
In your experience, well, why don't you tell us about your situation? What happened with you?
Okay, so I was in Omaha, Nebraska area. I was traveling with the, I've changed my plates now. I have private plates, just black with white text, not for hire, not in commerce. But I had the sovereign citizen starter plates you get on eBay, the white ones with the, everyone's seen it, right? You got to start somewhere. So went with those, and it was a beautiful sunny day. I was leaving the restaurant to go to my friend's house 3 miles away in Omaha to take a nap because we had been up. I had 3 hours of sleep. It was one of the best days, best weekends of my life. Before this, I'm a car guy. I was at a car event. It was amazing. I'm in a 1999 Cobra Mustang. Won top 50 award at an event right before that out of 2,500 cars. Like, it's not like I'm driving a beater Civic with broken windows, right? Nice, clean kept car. No. He tried to. So anyway, I am turning left, and there's a sheriff about 3 cars back, and as soon as I pass him in the waiting lane to turn left, he whips it over. I'm like, all right, here we go. So I turn left, immediately lights on, pull over into the parking lot. Hey, how you doing? I'm like, hey, good, how's it going? And then he says, what's going on with your license plates? And I said, sir, sorry, I don't have any license plates. And he said, why is that? I said, I'm not traveling in commerce. He said, give me your car keys. For what? So that's how it started, and then the entire 4 minutes and 30-something seconds before I was in the back of a cop car continued just like that. He was very demanding, we couldn't have a conversation. I have a travel binder which shows, documentation that, proof of ownership. I have a bill of sale, it's my car. I had insurance on the car. I didn't provide my driver's license because I was not driving. I made that very clear from the very start. I'm not driving, I'm traveling. I'm not for commerce, not for hire. They don't care, it doesn't matter. I showed him the binder, showed him laws, statutes, codes, definitions, UCCs, all that. He said, I'm not looking at anything you have in that stupid book. It's all fake. You have to give me your driver's license, registration, and insurance.
Now, wait a second. So what does that show? There is ignorance of the
law. Yep. So, as we've said many times, you have to educate. So I tried to educate, and he forcefully denied education. That's what happened.
Willfully, intentionally, and what? No. Starts with a K. There we go. Knowingly.
Yes, that's what I was about to say. So, I'm at Discovery, and I just got some 2 documents from the state, the prosecutor, and last week, and one of them was called a warrantless arrest affidavit.
Wait. Okay. First off, though, he's got to give some context here. Okay. A little bit more.
Yep.
So you ended up filing a motion to dismiss, right?
Correct.
Okay, we developed that all together, me, you, Matthew, collectively. And then what happened with that motion to dismiss?
It was denied by the judge, in my opinion, because he
but
didn't
why?
read it.
Why was it dismissed?
He said, the only thing he said on it in court, on the record, was, I don't see enough here to admit this.
Okay.
Which is not enough notice. That's like when you ask your parents, oh, can we buy this? When you're a kid, can we buy this? And they say, no. And you say, why? And they say, because. Right. That is not enough for me to defend myself in court properly as the defendant to be able to mount a case. You said no. Why? Because why? So then we formulated the formal written determination, a request for formal written determination, and the judge did not get what the purpose of it was at first, mainly because we have determined that judges do not read anything you file.
Okay, so wait, what you're saying is that you filed a motion to dismiss, and the judge ruled and denied the motion without giving you any reasoning whatsoever. So therefore, because there is no reasoning, there's no way for you to properly defend yourself based on not knowing why you was denied the motion to dismiss. So at your next hearing, what happened?
So that was the purpose of the next hearing. So at that hearing, I say, okay, I asked him, have you read this document in its entirety? What did they say? Yeah. You know, just you could tell he was just trying to scoot past that question. And so then I said, okay. And so I had sent a motion for a formal written determination. And in that formal written determination, I said everything. I said, hey, this is not in a lot of legalese. This is not enough information for me to set up a proper defense against. I need you, judge, to do your job and give me your actual reasons as to why it's not being, why you didn't admit it. So in court, he said, yeah, and okay, so we get to that part of court where we're discussing my motion for a formal written determination, my request. And he said, okay, you'll be heard on this matter. And or he was trying to skate over it. He basically said, well, I already gave you a determination. I already said it's denied. I said, hold on. That's not what I'm not saying that you did not formally say whether it was approved or denied. I'm saying you need to give me your exact reasons. Like, go through it's 3-4 pages. It's not like I send him 64 pages of crap. I said, yeah, we edited it between we sending it, so I don't know if it's in here. Actually, if you go to my case, it's probably in there. Anyway, so I laid out, I had to pause the judge before he was like, all right, and we're going to move on. I said, hold on. I need to make sure this is formally written, and Matthew's going to help me here. Because when you go into court, you kind of black out. You're just talking, and you're getting out everything you need to, but it's hard for me to remember what I said. Matthew was there,
Yeah.
and go for it.
Okay, so with this formal written determination, the judge was like, well, I already ruled on this, and I think what I said was right. Which tells us he never read it.
Because if you would have read my motion to dismiss, which was 15-ish pages, but very clearly I said, you broke this amendment, you broke this amendment, you violated this right, rule of lenity, everything. Like, it's very detailed. I don't think we could have put out a much better product than we did. We were very confident with it. Yeah, it's very detailed. And if you read this and you don't agree with it, you're just ignorant to the law or blatantly just rubber stamping denied. And that's how it was. So I was able to turn him around from trying to move on in court, move on to the next subject as quickly as possible, because that's what they want to do, just keep it rolling. Dollars per hour is what they're going for. And so I was able to turn him around, and he ended up saying something to the effect of,
Okay, well, he wasn't, what you had to do is you pulled out your written determination motion out and just said, hold on a minute, let me read this to you.
yes,
And he read off half of it,
4 paragraphs.
and then the judge was like, oh.
At one point, I was head down reading the document, but at one point I looked up, and the judge is a bald white man with glasses, and his glasses were on his head, which I'd never seen before once. And we've seen this guy a lot.
His fingers on the paper as he's reading it.
So he actually started reading it for the first time, clearly. And after I was done saying my piece, the judge was like, I see what you're going for here, Mr. Height. You are looking for specific reasoning as to why this motion has been dismissed. And I said, in my head...
Denied.
Yeah, denied. And in my head, I'm like, yeah, that's what the whole document's about. But anyway, so then he said...
Then he's like, you know, the court really appreciates that we like things specific and detailed. I'll make sure the court gets that done for you. I'll work on that really hard for you and get this all detailed out for you, exactly as you're asking for it.
Yeah, and so to be from previous to where he was going to railroad walk past as quickly as possible, to turn him around in 2 minutes' time, to being, okay, I get it, I'm going to give you what you're asking for. He said, I appreciate you asking for specific, the court appreciates specificity as well, and I'll give that to you. So it's possible to turn a judge around. Don't be scared of these people, they're just people too.
Yeah.
So then they also granted my motion for discovery, and I was beginning to get discovery, like I said, and we good to go on to the affidavit Yeah, so warrantless arrest affidavit. Listen to those words. Warrantless arrest. Can you arrest someone without a warrant lawfully?
Unless what? Wait, there is something. Wait, what? Gross misdemeanor and or felony. That's in every state.
So, I know I didn't fill in all the details, but I wasn't speeding, I didn't fail to blinker, like nothing. He pulled me over for a plate, which first off is a secondary offense. There was not a crime that I had committed. I didn't run over a child, I didn't steal, none of that.
There's no violation really as far as moving violation.
Correct, yeah, I was just going down the road.
Yeah.
So.
Which, is open as a matter of right for public vehicular. Not driving, but what?
Travel. Go to your Cam harps on this. Yep. Go to your county, look up your statutes, and it will have something, what he showed earlier, it'll have something extremely similar to that. They all do.
Yeah, normally it's under county road.
Yep.
So if you look up the definition of county road within your municipal city code and or county road is going to have that definition for you, okay?
So, back to the warrantless arrest affidavit, which is the most hilarious document title I've ever seen. Yeah. They admitted that they committed a crime, an unlawful act in the title of the document. So, and it's an affidavit, which is sworn under penalty of perjury.
I want to know what Sonny thinks of that. Did he write those up?
Are you willing to give any color? Are you willing to give any color on that? What was that?
What did he say? Oh, more looking at us. I love it. Good answer.
Sonny pleads the fifth.
Yeah, I get it. You're still doing your thing. No worries. Maybe we'll have a side convo later. But anyway, so they gave me two documents. One was the initial complaint without a verified complainant. There was no citizen that had said, hey, this guy's doing this crime. So they never called the cops and said to come get me. So no verified complaint, no verified complainant, no probable cause. So they gave me the complaint, which is otherwise known as your ticket, right? So on the ticket, he writes up his little blurb about what happened, which has a lot of inconsistencies. Let's start with that. And the two documents I got, the other one was the warrantless arrest affidavit. So he says the same story twice. I assume the same day is probably when he wrote them both up. And they are both quite different. A lot of different facts are in this. And where was I going? Where should I be going with this?
I don't remember which points were different. But
well, it's just
I want you to mention the discovery, the body cam.
Yeah, so Cam had a situation where he got body cam in how long?
Less than 10 days?
Yeah, and my arrest was September 30th of 2024, and I still have not gotten body cam because they have denied my FOIA request because it's part of an ongoing investigation, But now that we have discovery, they will have to provide it to me by the 30th. Interesting point. This is during court on the record. So we go to my motion to begin discovery, which is compelling the court to tell the state, the prosecutor, to begin providing me the evidence that I requested, which I was very detailed. I said I need this, right? Like 16 points. Body cam, cruiser. Oh, by the way, 6 cop cars showed up for me. 6. So I need every officer there's camera footage. I need all of their cruiser footage. I need all of their testaments they may have said, and any witness statements. Like, I need all of this. I need all of this to go to court, right? So when we brought up my motion in court, the judge says, okay, it's your turn to talk about this motion. How would you like to say? And I say, please grant me this relief, meaning all of the things I asked. And so he goes to the prosecutor, do you have any objection to this? And she says something to the effect of, also, this is a new prosecutor. We switched halfway through my trial, so she's new. And she says, well, I was going through the motion, and he said something about witness testimony, and there weren't any witnesses there. It was just him in the car. I don't know what he's even talking about. And I'm not exaggerating. That was her tone in court. And and then so he's like, okay, would you grant his request for these records? And the prosecutor said, I'd be happy to have a time where he could come and review it. And then the judge is like, do you have anything else to say, Mr. Height? And I said, yeah, I need record. I need that on a CD. I need it on a flash drive, email. I need the record for a case of appellate appeal and for trial.
Yeah, you asked for a physical copy.
Physical copy. And the judge says, do you have any objection to that, Miss McNary? And she says, I don't feel comfortable providing that.
Oh, my.
On the record, in court. Why would you be not comfortable providing that? That is my... So the judge, at that moment, the judge went, all right. It's like, have you ever heard anybody say that before? The judge was so confused, and he was like, all right. I'm going to go through everything we've discussed here today. I'm going to get you your formal written determination. I'm going to be very specific as you asked. I'm going to review your motion for discovery, which means read it for the first time. So he's going to read it for the first time, make his determination upon that, and I'll be getting back to you in the coming days. And we walked out. What was the energy when we walked out of the courtroom?
Really awkward. That prosecutor was nervous.
So let me before I was talking about when we actually left the courthouse, before we left, we wrapped up court, and we were the very last one out of 25-ish cases. 24 pled guilty or no contest, and most of them paid attorneys to do so. So they paid an attorney to say, my client would like to plead guilty. Imagine paying someone to do that for you. So anyway.
I also want to mention the judge had said regarding your discovery, he's like, well, normally there's no problem getting discovery, and you don't even have to. It happens
every day.
You don't have to make a notice or a motion, but I'm ordering the court to do this for you. I'm going to make this happen for you.
Yeah, so it was super awkward. It was. Don't be scared of these people. Don't be scared of these people. So, I'm shaking right now talking about this. I have irreparable harm. I have irreparable harm that every time I talk about this.
So you've never been in trouble before?
Oh yeah. Let me preface that. I have never even had a speeding ticket.
See,
like not a single thing in my life.
You've never been to court?
No, nothing.
But you're making the judge do what you want him to do, right?
Yep.
You got to move the court. You have to have power. You have to know that power. I'm going to mention some more things, then we're going to go on break. Is that all right? Everybody, you got one more thing?
I'm real close.
Okay.
Real close.
It's a quick wrap up.
Okay,
Yes.
wrap it up.
Yeah, so
okay.
After court, I walk up to the prosecutor. I'm like, hello, nice to finally meet you. And I have some time right now. I'm traveling 5 hours back and forth every time to court because I live 5 hours away. It's a very large inconvenience for me and all of my friends that come with me, which always take your friends to court. Always.
Yep.
I don't care if it's 1, 2, let's get 50 of your friends.
For
right?
real.
So that's why the beautiful part about the regional, get your regional friends together. Anyway, so I shake her hand. Nice to meet you. I have some time right now if you'd like to review that evidence. And so she says, oh yeah, let me wrap up. I'll meet you at my office right down there. Okay. Walk down there, wait 5 minutes. She comes up, open the door for her, and she's like, yeah, so the judge hasn't ordered anything yet on the discovery, so I'm going to hold off until I get something on that. So she backtracked. In court, on the record, she said, yeah, she said, what?
Oh, yeah, in court, she said, oh, yeah, just come to my office right after this.
We'll review.
We'll review it.
And then she 5 minutes later said, nope, never mind, I'm not doing that.
And she's like, I do have it all. I have all of it.
She, not in those words,
and then she said, so do you really think you're innocent in this one?
Yeah, she asked, she said, do you really believe you're innocent? Before that, she said, and this would be probably the 5th time that they offered a diversion to me. And the judge has said it 3 or 4 times. The prosecutor, the previous prosecutor, the county attorney's office has sent me letters in the mail, which I stamped, denied, sent back, all of it, right? So she asked me face to face, it's just in her office, which is like a entryway to the office, not her office. And she said, so you really believe you weren't breaking any laws or committing any crimes during this? And I said, yes. That's what I said,
Yep,
right?
she's just,
That's
like,
one
he's
word.
just like, yep. And then she's like, okay, well, we'll just wait for the judge to send that order. And that was it, and we left.
And so what we're trying to get across here, I think, is that you can be a little nervous, a little shaky. You can be a noob. You can have never done any of this before, but you can do it. And I'm fumbling my way through it, but with the power of Operation Wisedome, Cam, all of our friends in the group, we're approaching 400 members now. We're all doing it together. We, just like with Hayden and every other person in our group, we're all helping each other. And that's how we're able to do this. We need to stand up collectively for our rights. And the misconception yesterday, right? Like we're just some crazy people and we want to do crazy things. No, that is not it at all. I'm standing on what my creator gave me. And you should too. So that's what we got.
Woo! I want to say one thing on this real quick too. With Cam probably. So real quick, for anybody thinking, because I know we got a lot of new people in here who want to file stuff and haven't and all that, I want to say something really important. This is not just about fucking litigation. This is not just about criminal shit and, I might get pulled over one day and there might be an asshole cop, so like maybe I should kind of learn this, and it's like, kind of cool, or like whatever. This is about being an American. This is about being a fucking human being. This is about helping other people who might get fucked up, racist shit. This is about all sorts of different shit, okay? This is like so much fucking bigger than some dumbass criminal whatever. And I just don't want, because a lot of you guys are new, so, or haven't done a lot of stuff. I don't want people thinking that that's what this is. This isn't like, I need to learn this so in case some cop does something to me, blah, 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 blah. This is going to help you in your relationships. Women fucking crave men who fucking think and act like this. Men. And it's like getting worse and worse and worse, and women are fucking lonely, and they're like, what the fuck happened to the soul of man? What the fuck happened to the soul of man? It's going to help you in your work. Selling as an entrepreneur. This is massive. This is massive for your fucking career. It's so much bigger than just some fucking stupid, dumbass bullshit. I'm going to learn this so I don't have to deal with all this bullshit. It's like a slight bullshit insurance policy. That's not what this is. And I just wanted to be like super fucking clear for you guys. That's not what this is. This is like, I don't know of a whole lot of other things you could be doing in this world you're gonna experience this kind of spiritual and personal transformation. There's a lot of other cool things that I've done and Joey's done and Cam's done in those areas. So there's a lot of other really cool things that are out there. But this is everything, bro. I mean, these guys are coming up here. Have you guys ever fucking spoken in front of an audience before?
Not in this capacity.
Okay. So public speaking, most people are more afraid of public speaking than death, statistically. So just keep in mind, it's like, it's a full mind shift in every area of your life. And I think I just want to make sure is everybody tracking with that? Yeah. Okay, great. Right on.
That we don't get errors. We don't get faulty phantom cases. Everything is real and legit. And what I mean by that is the aspect that we ain't playing in relation to the developments of any documents that we do either. As you can see, this isn't some podunk looking document, okay? We have everything in here. Judicial notice, special appearance, rules of procedures, lack of jurisdiction. Everything that you can think of is what we're doing now. We used advanced prompts. We go very detailed. We use the best technology available. essentially. There's nothing better that you'll be able to find. I don't like to brag, but I'm gonna brag on this one. I think we're the first pro se litigant group in the world on this type of capacity. I'm just gonna say it.
Oh, yeah.
I really do believe that. So what we're gonna do is I wanna thank everybody for participating through this session thus far. We're gonna have more. Y'all have done really great. I know there's gonna be lots of questions. Y'all feel free to ask me any questions as we go into this 10, 15-minute break here. Y'all get up, stretch some legs, jump around, and we'll reconvene about 15, 20 minutes, okay? Good? Did y'all enjoy that? Give me a shout out.
Woo!
Good deal.
Give it up
Good
for
deal.
Cam. As Joey and Cameron have already talked about, I feel very differently about the 14th Amendment. A little different. Just a little tad differently than the 14th Amendment. But the thing is that you might say to yourself, you know, it's important to say, you might say to yourself, well, this is confusing, Brandon. I'm confused. And my answer is, I don't give a fuck. Because the thing is that you should be able to listen to 15, 20, 30, 500 different opinions. We should all be able to listen to 500 different opinions. We should be able to hold our own fucking courts. And we can have 1,000 people come in and testify and talk about what they think. We should still have the capacity to decide our own reality and decide what's best for people or yourself or your family, regardless. So you might say, well, Brandon, why are you talking with these guys who are pro-14th Amendment? Well, it's called the ability to perceive and the ability to evaluate information on a basic fucking level. That's what it's called. So I just wanted to clear that up. So I am going to be the total opposite of everything you're going to hear from these guys regarding this this whole thing. Only about 4 or 5 people raised their hand when I asked if anyone had read this page, which is a treatise on the word person, which is brand new. I just released it, and there's actually a bunch of other information that I'm going to add to it that I haven't even had a chance to add to it yet. So this is exciting, fresh, new, totally fucking crazy, and I think it's going to be better for a more of a linear presentation, whereas tomorrow I'll definitely be sure to get into all your guys' financial bullshit, so don't worry about that, okay? So with that said, this page is available at williamsandwilliamslawfirm.com. Anyone can go on there. You can go on there right now, and you just click at the top of the page. It'll say treatise on the word person. It's just a page on the website. You can click on it, you can go right to it. So the beauty of that is everything I'm going to be covering in this entire presentation is already completely at your fingertips in a completely organized manner. So if you'd like to review this information or share it with anyone, it's literally just type in the URL, click one single button, and then bang, you're there, which is beautiful. Thank you guys. Thank you. So with that said, let's get started. So this treatise, right? So it's the introduction part of the treatise is about, you know, I've been trying to figure out certain words for a long time, as some of you may know. Words like resident. My fucking God. Words like citizen. My fucking God. Words like person. And I've gone back and forth, and you know, at the beginning it was like, don't say the word citizen, and then it was like, citizen's evil, and then I changed, and then people were like, why are you changing? It's confusing. Did you pay me to be here, motherfucker? No. That's the beauty of giving it away for free. Oh, I'm confused. Last week you said it wasn't supposed to be citizen, and this week you're saying, oh, great, fuck you, you're confused. Great, cool, fuck off. I love it. That's how I feel, because I'm trying to learn this shit too, bro. I'm trying to learn this shit too just as much as all of you guys are. You know what I mean? I may seem like I know more about it or whatever. That's just because I think about it and work on it all the time. So this is basically like the word individual, the word person, the word citizen. I finally felt like I had a fucking breakthrough on the subject, right? And I've had a bunch of other smaller breakthroughs throughout the years, but this one I felt like was like the kaboom where it all came together. And that's why I wrote this. So it's sort of like 3.5 years of work, I feel like, went into writing this thing. And I've been on a couple shows talking about it, but overall I haven't really talked about it too much because it's just so new. So this is the current situation, scrolling down to section 2, the current situation. In today's world, the word person is so far gone and so beyond confusion that it is in a state of complete oblivion. Now, why do you think that is? Deliberate. It's totally deliberate. It's done to confuse you. You gotta be fucking kidding. Why in the fuck is the word person so confusing and fucked up and just, it just doesn't make any sense. Why does it have to be like this, right? So the word individual is really one of the most important words because you start looking up the word person and you'll see it's an individual and then a whole bunch of legal fictions. It's an individual and a corporation, trust, estate, partnership, association, blah, blah, blah. It's all these corporate fictions. And we know we aren't those things. I know I'm not a trust. I know I'm not a corporation. I know I'm not those things. But an individual? That sounds like me. I'm an individual, right? But the thing is, they never fucking define the word individual anywhere. It's almost impossible to find any definitions on it. Oh, I wonder why that is. Well, it's pretty fucking obvious, right? So if you look in Title 8 of the United States Code, which is all about nationality and aliens, right? The definition of the word person is an individual or an organization. And the word organization means literally everything under the sun, moon, and stars. I'm not even going to read it. It's just like literally everything. It's just like, it starts off and it says like, includes all the following, but it's not even like an exhaustive list. It could include like other things. And then like, it says like incorporated and unincorporated anything. So it's just like literally anything, basically. The word organization means like fucking literally anything, right? So if we go into Black's Law and we read the definition of the word individual, it says, because if you can't find the definition in the statute, you have to go to Black's Law because it's probably like not a special definition used in that area, but it's probably just a normal ass definition you need to go look up, right? So the definition is, as a noun, the term denotes a single person as distinguished from a group or class, and also very commonly a private or natural person as distinguished from a partnership, corporation, or association. But it is said that this restrictive signification is not necessarily inherent in the word, and that it may, in proper cases, include artificial persons. Well, fuck you. It's like, thanks for nothing, you piece of shit. Thanks for nothing, State versus Bell Telephone Company, 36 Ohio, 310, whatever the fuck the rest of it is. Thanks a lot for nothing. Well, actually, it's you know, it could be this and that. And, it generally designates a human being as, you know, different from a legal fiction, because oftentimes the word person does have legal fiction in there. Could be a legal fiction. You never know. Never know where the wind blows, right? And it's and then here's the definition of the word organization coming out of the word person from Title 8. The term organization means, but is not limited to, an organization, corporation, company, partnership, association, trust, foundation, or fund, and includes a group of persons, whether or not incorporated, permanently or temporarily associated together with joint action on any subject or subjects. So this is right here what we're doing right here, right now, legally, a Title 8 organization. I mean, it has the word persons, so we're going to get into that later. So is it really? Right. There's a section here, this is pretty wild, because when you understand that the definition of the word person includes organizations, and organizations means literally everything under the sun, moon, and stars, that definition of the word person from 8 U.S.C. 1101 is the one that applies for the passport system. So the definition of the word person when it comes to passports is the one from 8 U.S.C. 1101. So who can get passports? Individuals or organizations. What's an organization? Anything. So this little club we have here, we can give it a name and then go get a passport for it. The birthday of the person that we name here is today, or yesterday. So I'd literally list on there, yesterday would be the birthday of that person. And, you know, I've never seen anyone do this. I keep telling people to do it. I've never seen anybody do it. I'll do it at some point when I get bored. But it's one of those things where you have to actually, it's such a mind fuck. Trusts are persons. They can get a passport. It'd be your picture. I got a whole fucking binder full of fucking passports for all these different persons, and my picture's on every single one, looking like this, looking like that. Fucking frog, like one of those Mario 3 frog outfits with a little fucking, all of it. I'll have 1,400 fucking passports. God, yes. One day, I'll start doing it just for fun. I'll have a whole playing card collection, and I'll put them in like little booster packs, and you open it up, and it's all my passports. You know what I mean? So it's ridiculous, obviously, right? So if we look at another definition of the word person, for example, from the tax code, it's one of my favorite definitions of the word person, because I think it's not too long, it's not too short, it's pretty good. The term person shall be construed to mean and include an individual, a trust, estate, partnership, association, company, or corporation. Besides the word individual, people really wouldn't get that tripped up by this if it wasn't for that word individual, right? It's really the only word that has caused all of the difficulties with the word person. Because if the word individual wasn't there, no one would have any confusion at all whatsoever as to what the fuck anyone's talking about, right? So, the original definition of citizen and people. We're going all the way back, 1790. The Naturalization Act. It says here, be it enacted by the Senate and House of Representatives of the United States of America in Congress assembled, that any alien, being a free white person, who shall have resided within the limits and under the jurisdiction of the United States for the term of 2 years, may be admitted to become a citizen thereof on application to any common law court of record in any one of the states wherein he shall have resided for the term of 1 year at least, and making proof to the satisfaction of such court that he is a person of good character and taking the oath or affirmation prescribed by law to support the Constitution of the United States. The word alien, just so you guys know, it means somebody who, at that time, it meant somebody who's just not a citizen. Now it's a little different. It means somebody who's not a citizen or non-citizen national, as per Title 8 U.S.C. 1101. But at that time, in 1790, it just meant somebody who's not a citizen. Okay? So, if we break it down into 4 subsections as to what someone needs to do or have in order to naturalize. So the first thing, it's so simple, you weren't already a citizen. If you're born here, then you wouldn't naturalize because you already have native-born citizenship. But if you're an alien and you want to come here, even to this day, even right now as we're standing here, there's 4 things that you have to take into account. And there was a couple of updates to this. So you had the Naturalization Act of 1790, and then you had like one more update in like 1795, and then you had one more update in 1805. And I will plug in some of the 1802. I will plug in some of the 1802 stuff here because that's actually the one that's still active even to this day, is the 1802 one. And that's the brand new stuff that I haven't released anything on yet, okay? So originally, it was 2 years you had to stay here as a resident before you could become a citizen. Now it's 5 years. That's one of the big changes in the 1802, okay? So 4 things a person has to have to naturalize as a state citizen. This has nothing to do with immigration. This has nothing to do with the federal government. The federal government did not exist yet. This has nothing to do with anything in today's world. I don't even think there are these common law courts they're talking about, so you can't even go and fucking give anybody anything. It's just like, that's why you don't see any of this information anywhere. Because it's still there, it still exists, but like, how the fuck do you do it? You just do it. You don't interface with the federal government at all. It has nothing to do with them. It should, but for whatever reason it doesn't. There's 4 things that you have to know in order to naturalize or be or whatever. Number 1, was previously an alien. That's pretty simple. I'm not a citizen, I want to be a citizen. I'm not a citizen, I'm an alien. Okay. That's pretty simple, right? Number 2 is the shocker. This is the big shocker one. You have to be a free white person. And we're going to get into what that means. That's where things get spicy. Number 3, you have to have resided as basically somebody who's naturalizing. You aren't a citizen yet, you're working on it. That's basically the new way that I understand the word resident, right? The word resident is somebody who's in a state who's basically doing their alienship 5 years that they have to do to become a citizen, and they haven't completed that process yet. But if you're born here as a native-born citizen of Indiana, like myself, and I think Joey was born in Indiana, the word resident has absolutely fucking nothing to do with you because you weren't an alien before. So why are you behaving like you're a fucking alien trying to get citizenship? Every time you put the word resident on anything, and you have to put it to get a fucking driver's license. Resident means alien working on his residency in order to become a citizen. That's what the word resident means. And I know I've gone through a lot of fucking bullshit with that, and I've gone back and forth, and I've had all these different ideas and definitions. I think this is a whole new level of clarity, and I really like this. And I know it's been confusing. It's been a confusing ride for me, too. These are words that are just the biggest fucking nightmare to try to figure out what they mean, man. And it's just like, it's why we live in a world that's just so fucked up, because nobody knows, right? The 4th thing, if you're naturalizing into a state, as a state citizen, which we're going to get into, demonstrates good character and swears an oath to support the U.S. Constitution. And that's it. To this day, 1802 Naturalization Act is still alive. And those are the 4 things you have to do. Previously be an alien, be a free white person, you have to reside in the state, in one of the 50 states for 5 years, but it has to be 1 year at least in the state of application for citizenship. You have to demonstrate good character, and then swear an oath to support the U.S. Constitution. If you do all those things, congratulations, you are a state citizen. And that's the new stuff that I haven't released yet. That's the brand new stuff that I haven't released yet. I have some documents. I'm going to put it on here. There's going to be a link to a Dropbox, and you guys can read the original Naturalization Act of 1802, which is very, very, very short. It's 2.5 pages. It's super easy to read, actually, back when they actually gave a fuck. You know what I mean? So basically, what do we need to know from this point, right? Well, obviously, the first thing we have to look at is, what is the definition of free white person? Meaning all persons belonging to the European races then commonly counted as white, and their descendants, including such descendants in other countries to which they have emigrated, with an E. Now, when you do a history, when you go back and study the history of America, it was pretty much all just Europeans that were coming here. And pretty much all just Europeans who were here. So no one even questioned any of this. There wasn't like an issue. It wasn't like everybody in the world's trying to come to America for the first while. I would say, up until like the Dred Scott case, we just really didn't have a lot of people trying to come to America like what we have today, right? So this sounds so fucking crazy to us today, but if you do the research, this was like, everyone here is already fucking this category. Like, it wasn't like, it's like Japanese people saying that you have to be a free Japanese person to naturalize into Japan. Literally, I'm not even kidding. That's what it is, right? And Japan does not like other people coming into their culture. They do not like any other fucking race coming. You can come, you can hang out, you can eat our shit, enjoy our culture, and get the fuck out. That's Japan. And that's a lot of other cultures too, right? And you can say that's racist. Well, they really just do not give a fuck at all. You can call them racist all day, all night. They do not give the slightest fuck at all. It's come in, eat our food, enjoy your time, and get the fuck out. You got 2 weeks. That's Japan, okay? So the idea that we were any different, or the idea that this was any different is stupid, because the thing is that we were a new country. We were building this from fucking scratch. We all came from England, which is a European country. So at the time, it made fucking perfect sense. It's 1790. We just started this thing. And then the other definition here gets into all the subclasses. It includes all European Jews, more or less intermixed with peoples of Celtic, Scandinavian, Teutonic, Iberian, Latin, Greek, and Slavic descent. It includes Magyars, Lapps, and Finns, and the Basques and Albanians. It includes the mixed Latin, Celtic, anyways. So you get, it's very, 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 very specific as to which European races they are talking about and which ones they are not.
But isn't the interesting one the Moorish inhabitants?
Yeah, Moorish inhabitants are listed. It says here, and Moorish inhabitants of Spain and Portugal, because you got to think too, there were Moorish people in Spain and Portugal, which are Europeans. That's correct. We're going to get into that in a minute. So this was a very simple and we can get into, well, what's the definition of good character? Displays good character. Well, they cover that in the Naturalization Act. It's very simple. It's not 416 pages from some cocksucking bar card piece of shit. It's like a few sentences of like simple shit. And you don't need to be a lawyer and you don't need to be a genius to read it. Back when the country, people who, were writing these things, they actually cared, and they actually cared about the country, and they actually loved the country, and they loved what we were doing. And they weren't trying to just bill God knows who to write a 500-page piece of shit that no one will ever read or understand. Okay? So the introduction of the word persons. Dred Scott versus Sanford case, 1857. So what is the Dred Scott versus Sanford case? We're going along, we're all European white people, and we have the African descendant slaves. We're doing just fine. No one ever thought to question it. And then this guy named Dred Scott, who was emancipated, decided he was going to stand up and do something. Like I say at the end of this tree, is one of the most badass motherfuckers to ever walk the earth, in my opinion. He went all the way. He went all the way to the Supreme Court, and everybody, I can't believe somebody didn't try to kill him or something. I literally just cannot believe. You guys think in today's world, everyone's going to kill everybody, and Brandon's going to be dead, and Joey's going to be dead, and everybody's going to get murdered by the FBI. This is nothing compared to someone like a fucking Dred Scott circa 1857. Oh my God. He could die, and someone could literally watch a white man kill Dred Scott in broad public, and no one probably would even ask a fucking question. That's how fucking badass Dred Scott was. They could be like, shoot him right there live in front of a whole audience of people, and nobody would have done shit about it. That's how fucking bad it was, okay? So Roger Taney, which is the justice on this case, and to Cam's point earlier, administrative judges. Now keep in mind, this is back when we actually had judges. We actually had honorable justices. We actually had real courts. So the terminology here might sound different than what you've heard in Cam's presentation, because it is. Everything that Cam said is true. Everything I'm going to say is true. They sound very different. Well, the reason why is because in 1857, we still had all the stuff that you guys think the court should be. We still had all the stuff that you guys think things should be. And if we had what we had in 1857, I think everybody in here would be quite thrilled about it. That's what we had. Real courts, real judges, real shit, real laws, 2 pages. The whole Naturalization Act is 2.5 pages. Anyone can read it, I promise you. I'm going to put it up on this page probably in the next few days. This is what Mr. Tanny has to say about the situation. The words people of the United States and citizens are synonymous terms. So he's saying, you know, we the people or people of the United States, and the word citizen is the same shit. That's what he's saying, okay? They both describe the political body who, according to our Republican institutions, form the sovereignty. For Cam Wilson. And who hold the power and conduct the government through their representatives. They're what we familiarly call the sovereign people, and every citizen is one of this people and a constituent member of this sovereignty. Now, this whole case is about a slave who basically was emancipated and he was trying to get citizenship. So that was the entire basis of the Dred Scott case. Mr. Scott, I don't know if his first name was Dred and his last name was Scott, but Dred Scott. So what they're saying here is the question before us is whether the class of persons described in the plea of abatement compose a portion of this people. So they're telling you what the people is. This is the people. Boom, 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 boom. This is what a people is. And then the question before us is whether this class of persons, a different class, compose a portion of what we just spoke about a minute ago called the people. And are constituent members of this sovereignty. And this is where it gets bad. How bad? Really fucking bad. We think they are not, and that they are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides and secures to citizens of the United States. On the contrary, they were, at that time, considered as a subordinate and inferior class of beings who had been subjugated by the dominant race, and whether emancipated or not, yet remained subject to their authority and had no rights or privileges, but such as those who held the power and the government might choose to grant them. In the opinion of the court, the legislation and histories of the times and the language used in the Declaration of Independence show that neither the class of persons who had been imported as slaves nor their descendants, whether they had become free or not, were then acknowledged as a part of the people, nor intended to be included in the general words used in that memorable instrument. It is difficult at this day to realize the state of public opinion in relation to that unfortunate race, which prevailed in the civilized and enlightened portions of the world at the time of the Declaration of Independence and when the Constitution of the United States was framed and adopted. But the public history of every European nation displays it in a manner too plain to be mistaken. They had, for more than a century before, been regarded as beings of an inferior order and altogether unfit to associate with the white race, either in social or political relations, and so far inferior that they had no rights which the white man was bound to respect, and that the Negro might justly and lawfully be reduced to slavery for his benefit. That's fucking wild. For his, I'm going to read that again. And that the Negro might justly and lawfully be reduced to slavery for his benefit. Where am I at? He was bought and sold and treated as an ordinary article of merchandise and traffic, whenever a profit could be made by it. This opinion was at that time fixed and universal in the civilized portion of the white race. It was regarded as an axiom in morals as well as in politics, which no one thought of disputing or even supposed to be open to dispute. And men in every grade and position in society daily and habitually acted upon it in their private pursuits as well as in matters of public concerns without doubting for a moment the correctness of this opinion. Does it get any fucking clearer? I'm not even done yet. Does it get any fucking clearer? And in no nation was this opinion more firmly fixed or more uniformly acted upon than by the English government and the English people. They not only seized them on the coast of Africa and sold them or held them in slavery for their own use, they took them as ordinary articles of merchandise to every country where they could make a profit on them, and were far more extensively engaged in this commerce than any other nation in the world. This is the next part. I know you're just going to get worse. It only gets worse. Here's the next part. But there are two clauses in the Constitution which point directly and specifically to the Negro race as a separate class of persons, and show clearly that they were not regarded as a portion of the people or citizens of the government then formed. Dred Scott versus Sanford, 1857. We were already moving into a civil war. Guess how this case affected us during that time period. Accelerated us very heavily into the Civil War. But you got to realize when you read the whole thing, they're telling you, Tanny's telling you, like this thing, Tanny's basically saying like, bro, like no one's ever even questioned this shit. No one's ever even thought that it was even something to be questioned. That's how unquestioned it was. It wasn't just like, hey, whoa, like nobody ever fucking talked to us about this. It was like, bro, nobody ever even thought to think about thinking about it. They go that far. They go that. It's not just like, oh, no one said anything. No one said anything, and no one ever even thought that they could or should or it was so normal, and it was so accepted, and it was so in this case they go all the way back to like 1709 or 1705. This predates America. He's not saying America, he's saying the English countries. He's saying basically the UK essentially, right? This isn't even an American thing. This goes back even before that. So we go into the Civil War, right? The free white people, we the people, free white people were considered people, and this particular term, which we're going to get into in a moment, was considered persons. And Dred Scott versus Sanford, basically what happened was, it's just, the evidence is just so overwhelming, and it's just been this way for so long, and it's just so extensive that this is what it is. Whether you like it or not, whether we like it or not, whether Roger Taney likes it or not, it just didn't make a difference. It's just, This case, if you read this case extensively, it's the entire history of slavery all the way through all the territories and states and everything else. Every single state, they had laws on mulattoes. Mulattoes can't date white women. They had laws on emancipated slaves can't date white women. Emancipated slaves can't get together in public. They'd be arrested. All sorts of craziness. It's all in this case, if you care to read it. So, obviously, you know, in this document here, I have a part about, you know, racism, classism, you know, and I'm talking about how, you know, you hear this and you think this and you say, oh my God, this is so awful. These people are so awful. Well, the thing is that they never even questioned this. It was never even like a moral dilemma. This was never an ethical or moral dilemma. This is like, we wake up, we enjoy our coffee in the morning for 150 years. And then all of a sudden, people are like, oh my God, coffee, you can't be drinking coffee, blah, blah, blah. And it's like, whoa, what the? And then all of a sudden, it kind of blows up, and then it's like, holy fuck, all of a sudden, everybody's upset about people drinking coffee, and then like the judges come out and they go like, guys, I don't know what the fuck's going on. Nobody's ever even thought about this for 150 years. Nobody's ever even thought that this was something we should even be talking about. And now all of a sudden, this is big fucking issue. Like, okay, let's take a look. So you guys have to realize we brought that over from England. It's an American thing, yes, but it's not American rooted. It's rooted in the English culture. Common law comes from the English culture. So common law and this kind of racism are pretty much married together, if you think about it, right? So then we have the Civil War. We're going through the Civil War, you know, killing each other, the whole thing. Then at the end we have the Reconstruction, right? We're reconstructing the country. And basically the 13th Amendment comes out, which frees all the slaves. It makes involuntary servitude illegal, banishes all involuntary servitude and slavery. There was a problem, though. Because of that free white person thing in the Naturalization Act, all of the emancipated slaves had no ability to gain citizenship. I'm not 100% sure as to exactly what that meant in the society, because we didn't have things like driver's licenses and all this other bullshit, so I'm not sure exactly why they wanted citizenship. I'm not sure exactly like what it is they were trying to achieve, but they just couldn't function for some reason in the society. And so there was a case that was done to try to fix this and clean up this issue called the Slaughterhouse cases. The Slaughterhouse cases was to fix this issue. We have all these emancipated slaves. The 13th Amendment is here. Now what do? We have a whole new problem on our hands. They probably didn't know they were going to have these kind of issues. So they're like, fuck, okay, now we got to figure this thing out. This is the case, in my opinion, Joey and Kim may have different opinions on this, that destroyed the country. And to this day, you can find a lot of judges and Supreme Court justices, including the honorable, I consider him pretty honorable, Clarence Thomas is one of our Supreme Court justices. He's like one of the only black guys on the Supreme Court. I think he's a good guy, but he's talked about the Slaughterhouse cases being essentially bullshit and that something needs to happen with it. Now, then you can ask the same question of, well, why don't you do something about it then, bro? You know? So it goes both, I mean, whatever, I don't know the guy that well, but he, you know, I think he's a good dude, but I don't know, I haven't extensively looked into him. I wrote to him, I haven't heard back from him yet, we'll see. So, in the Slaughterhouse cases, they're talking about the first line of the 14th Amendment.
Is it worth mentioning that in England, William Wilberforce in 1807 got through the Anti-Slavery Act, which actually started to change English thinking about black people, and that black people were not merchandise, but they were actually human beings, according to the Bible, and that they needed to stop trading black people, and that then led to the Dred case.
Could be, I don't know. I mean, Dred Scott's pretty clear. They definitely had not shifted that direction until this case, which we're going to go over right now. Dred Scott, obviously, they were not of that thinking at all. So the first line of the 14th Amendment, all persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. That sentence has been talked about nonstop since the day it was written. And even Samuel Freeman Miller talks about that. He's like, God damn, this thing, since it was written, it's just everybody and their mother's been talking about it, right? So part of the Slaughterhouse cases, too, was like, God damn, there's so much confusion around this. We need to sort out this confusion. We need to sort out the confusion of the 14th Amendment and what it means in relation to all of these released slaves and their citizenship. This is what he says. The first section of the 14th article, to which our attention is more specially invited, opens with a definition of citizenship. Not only citizenship of the United States, but citizenship of the states. No such definition was previously found in the Constitution, nor had any attempt been made to define it by act of Congress. It had been the occasion of much discussion in the courts, by the executive departments, and in the public journals. It had been said by eminent judges that no man was a citizen of the United States, except as he was a citizen of one of the states composing the Union. So what is he saying? If you said in 1857, I'm a U.S. citizen, that's not actually a legal classification. We could say that just privately, oh, I'm a U.S. citizen, especially if you're in another country. But the legal classification of where your citizenship lies would be with one of the states of the Union. So you wouldn't write U.S. citizen on like a fucking document. That wouldn't work back then, right? It would be Californian or Hoosier, New Yorker, Texan, because these are all separate nations. It's a nation of nations. So he says here, those therefore who had been born and resided always in the District of Columbia or in the territories, though within the United States, were not citizens. Only the states of the Union had any sort of citizenship that was actually attached to all the stuff that we think we have and all the things that we operate off of, right? So he says here, then all the Negro race who had recently been made free men, referring to the 13th Amendment, were still not only not citizens, but were incapable of becoming so by anything short of an amendment to the Constitution. To remove this difficulty primarily, and to establish a clear and comprehensive definition of citizenship, which should declare what should constitute citizenship of the United States and also citizenship of a state, the first clause of the first section was framed. The first observation we have to make on this clause is that it puts to rest both the questions which we stated to have been the subject of differences of opinion. It declares that persons may be citizens of the United States without regard to their citizenship of a particular state. And it overturns the Dred Scott decision by making all persons born within the United States and subject to its jurisdiction citizens of the United States. Here's the next sentence. That its main purpose was to establish the citizenship of the Negro can admit of no doubt. We're talking about a U.S. citizen right now, by the way, for those of you who aren't aware. We're talking about what a U.S. citizen is. So what is a U.S. citizen? And the U.S. citizen category came from The 14th Amendment, which was interpreted to mean this in this case called Slaughterhouse. So what was the main purpose for the creation of the U.S. citizen category? Its main purpose was to establish the citizenship of the Negro. Yeah, well, we're going to get into that. The next observation is more important in view of the arguments of counsel in the present case. It is that the distinction between citizenship of the United States and citizenship of a state is clearly recognized and established. Not only may a man be a citizen of the United States without being a citizen of a state, but it is an important element is necessary to convert the former into the latter. He must reside within the state to make him a citizen of it, but it is only necessary that he should be born or naturalized in the United States to be a citizen of the Union. That's pretty complicated. That's definitely where I think things went off the rail for these guys, right? So what he's saying is a U.S. citizen can always naturalize into a state. They would do it through the Naturalization Act of 1802. So if you're born as a white man in the District of Columbia, you would be a U.S. citizen, but if you would like to change that and become a state citizen, you would go through the same naturalization process found in the Naturalization Act of 1802, just like anybody else. That's what he's saying. Now, Negroes would not have that option because they're not considered a free white person. Next line here. It is quite clear then that there is a citizenship of the United States and a citizenship of a state, which are distinct from each other and which depend upon different characteristics or circumstances in the individual. Now, prior to this, in the Dred Scott case, at the very beginning, they said people of the United States and citizens are synonymous. They're members of the sovereignty. State citizens are those sovereign citizens. State citizens are those members of the sovereignty. What we're talking about now is not. We think this distinction and its explicit recognition in this amendment of great weight in this argument, because the next paragraph of this same section, which is the one mainly relied on by the plaintiffs in error, speaks only of privileges and immunities of citizens of the United States and does not speak of those of citizens of the several states. Of the privileges and immunities of the citizens of the United States and of the privileges and immunities of the citizen of the state and what they respectively are, we will presently consider. But we wish to state here that it is only the former which are placed by this clause under the protection of the federal Constitution, and that the latter, meaning state citizens, whatever they may be, are not intended to have any additional protection by this paragraph of the amendment. Meaning the federal Constitution has fucking nothing to do with state citizens. Nothing. Totally irrelevant. If then there is a difference between the privileges and immunities belonging to a citizen of the United States as such, and those belonging to the citizen of the state as such, the latter, meaning state citizens, must rest for their security and protection where they have heretofore rested. Meaning up until this point. Like everything from 1776 up until now, that's all your guys' shit. This new thing we're doing now, that's for something different going forward. For they are not embraced by this paragraph of the amendment. White people are here. You guys already have your shit. We're done. Release Negroes after the 13th Amendment. This is for you guys. Very clear. What is the first sentence of the 14th Amendment? All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. Reside means they are not a citizen. All Negroes born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States, and they're basically not citizens of a state when they're inside of a state. That's what the first sentence of the 14th Amendment is actually saying. And he said multiple times, this has nothing to do with you white people. Nothing. This is really clear in Ellen R. Van Valkenburg versus Albert Brown. This is like getting hit with a fucking sledgehammer. This is a California Supreme Court case from 1872. Listen to this one. This is just like fucking, I mean, you don't even need to fucking think about this one. No white person born within the limits of the United States and subject to their jurisdiction, or born without those limits and subsequently naturalized under their laws, owes the status of citizenship to the recent amendments to the federal Constitution. The history and aim of the 14th Amendment is well known, and the purpose had in view in its adoption well understood. That purpose was to confer the status of citizenship upon a numerous class of persons domiciled within the limits of the United States who could not be brought within the operation of the naturalization laws because native born and whose birth, though native, had at the same time left them without the status of citizenship. These persons were not white persons, but were in the main persons of African descent who had been held in slavery in this country, or if having themselves never been held in slavery, were the native-born descendants of slaves. Prior to the adoption of the 14th Amendment, it was settled that neither slaves nor those who had been such, nor the descendants of these, though native and freeborn, were capable of becoming citizens of the United States. Dred Scott versus Sanford. The 13th Amendment, though conferring the boon of freedom, means benefit of freedom, upon native-born persons of African blood, had yet left them under an insuperable bar, meaning impossible to overcome, bar, as to citizenship, and it was mainly to remedy this condition that the 14th Amendment was adopted. The 14th Amendment and U.S. citizenship had nothing to do with white state citizens that made up we the people. Now the word Negro. We say African American. Oh, African American. We want to be kind. We want to be gentle. We say, oh, African American. Legal definition is as follows. The word Negro means a black man, one descended from the African race, and does not commonly include a mulatto. Next definition. But the laws of the different states are not uniform in this respect. Some including the description Negro, one who has 1/8 or more African blood. This one's really important, I think, for most white people. We just don't know these things at all. This is honestly one of the most important definitions right here. Is term Negro means necessarily person of color, but not every person of color is Negro. African blood. How much African blood? Who fucking knows? And that kind of shit is never going to fly in today's society. So If you ask me, what's the legal definition of Negro? It's a fucking, it's like the fucking dinosaurs. It's gone. It's a fucking T-Rex. It doesn't exist anymore. What are you going to do, a 23andMe and the DOJ is going to press charges because you got 12.8% African blood? Oh, God, get the fuck out of here. They're all liberals. They're all fucking liberals. It's never going to happen. It's never going to happen. The fucking liberal piece of shit DOJ attorney I'm working with now, he'd fucking kill himself before he'd bring a charge like that or a cause of action. He'd hang himself right off his fucking Tesla. Definition of mulatto. A person that is the offspring of a negress by a white man or of a white man by a white woman by a Negro. Definition number one. Definition number two. In a more general sense, a person of mixed Caucasian and Negro blood or Indian and Negro blood. Definition number three. Properly, a mulatto is a person, one of whose parents is wholly black and the other wholly white, but the word does not always, though perhaps it does generally, require so exactly even a mixture of blood, nor is its significance alike in all the states. So what does the word Negro mean? It means fucking Tyrannosaurus Rex, as far as I'm concerned. Doesn't exist. It's a extinct species that's not around anymore. And if it is, no one's ever going to bring those claims or do anything about that, so it doesn't fucking matter. So by the end of the Slaughterhouse cases, we've already figured this all out. The word persons is this, colored people of African blood, and then in certain areas they were very specific about how much African blood, and then it's like, well, hold on a second. You guys didn't have 23andMe. You guys didn't even have fucking, running water, hot water. How in the fuck did you determine that somebody was 1/8 African blood? And it comes down to presumptions. Really, it does. 301, Rule 301, presumptions. Everything that happened in the black race is all because of a bunch of bullshit presumptions. To some degree. I mean, I'm sure it was worse than that because this goes way the fuck back. But so if you go in and you say, I'm a free white person, fill out a form. If the form has a box Negro and you check it, if the box says black and you check it, that's your presumption. Well, he checked the box. Now, what happened is in 1886, we have an expansion of this term persons. And it comes out of a case called Santa Clara County versus Southern Pacific Railroad Company, 118 U.S. 394. And here's the exact two sentences that cause this expansion of definition. One of the points made and discussed at length in the brief of counsel for defendants in error was that, quote, corporations are persons within the meaning of the 14th Amendment to the Constitution of the United States, end quote. Before argument, Mr. Chief Justice Waite said the following, quote, the court does not wish to hear argument on the question whether the provision in the 14th Amendment to the Constitution, which forbids a state to deny to any person within its jurisdiction the equal protection of the laws, applies to these corporations. We are all of opinion that it does. Bang. This is where the Supreme Court began the expansion of the 14th Amendment definition of the word persons. Now let's go back and reread the definition from the tax code of the word person. The term person shall be construed to mean and include an individual, a trust, a state, partnership, association, company, or corporation. It's a 14th Amendment definition. So the actual definition of the word person is the term person shall be construed to mean and include a Negro, a trust, a state, partnership, association, company, or corporation. And why is that? Because Negroes were articles of merchandise. They were things of which were owned. They were res in a trust. They were the asset in a trust if they were put in a trust. No different than a trust, an estate, a partnership, association, a company, or a corporation. They had no right to the Constitution. They had no right to the Bill of Rights. They had no right to speak freely. They had none of these things. They were nothing. They were not different in the eyes of the law from a trust, estate, partnership, association, company, or corporation. It's the same class. Definition of the term individual. So if we go farther into this term and we go to 1 U.S.C. 8, it's entitled Person, Human Being, Child, and Individual as including born alive infant. That's the name of 1 U.S.C. 8. And it says here, in determining the meaning of any act of Congress, of any ruling, regulation, or interpretation of the various administrative bureaus and agencies of the United States, the word person, human being, child, and individual shall include every infant member of the species Homo sapiens who is born alive at any stage of development. Second section is the definition of born alive. As used in this section, the term born alive with respect to a member of the species Homo sapiens means the complete expulsion or extraction from his or her mother of that member at any stage of development who after such expulsion or extraction breathes or has a beating heart, pulsation of the umbilical cord, or definite movement of voluntary muscles, regardless of whether the umbilical cord has been cut and regardless of whether the expulsion or extraction occurs as a result of a natural or induced labor, cesarean section, or induced abortion. So every single separatable article in a birth is considered itself, by itself, a live birth. The placenta, when disconnected, is considered its own entire separate live birth. The umbilical cord is its own entire separate live birth. If there was some, part of the body that came off or something during birth or something happened, that part of that body would also be considered an entirely separate live birth. So you have to ask yourself, who the flying fuck is on the birth certificate? There's like 13 people coming out of that mom. Who the fuck's on the goddamn thing? There's only one birth certificate. Individual includes every infant member of the, okay, so what if you're not an infant? What's the definition of infant? I think it's like 18 or 21, age of majority. So when you hit age of majority, the words person, human being, child, and individual, as far as I'm concerned, wouldn't apply to you at all. So the word human being also wouldn't apply to you. As far as I'm concerned, that's the way it is. I mean, so by saying individual, you're saying either child or Negro or trust, estate, corporation, partnership. One of the only areas that the word individual is actually defined is in 5 U.S.C. 552A. And it says here, the term individual means a citizen of the United States or an alien lawfully admitted for permanent residence. And that would be in reference to the District of Columbia. Because the term permanent residence, when it comes to a state, doesn't exist. That's a fucking complete bullshit term. Doesn't exist. It's impossible. There is no such thing as a permanent resident. There's a resident. A resident in a state is somebody who's doing their 5 years. They're an alien, and they need to be in the States for 5 years, 1 year in the state where they'll be completing their citizenship. So I could go all over the United States for 4 years, but then for California, I have to be in California for that last year in order to get California citizenship. And in that system, which is based off the Naturalization Act of 1802, there is no such thing as a permanent resident. There's a resident for 5 years, and then now you're a citizen. End of story. When you go deeper and deeper and deeper into the United States Code and all the stuff it talks about in terms of the District of Columbia, there's only one person that I've ever found evidence to that actually domiciles in the District of Columbia. Everybody else is a fucking resident. Can you guess who that one single person is? Joey's going to love this one if he's not aware of it. 36 USC 70501. 36 USC 70501 is the only organization I've ever found that domiciles in the District of Columbia. That organization is called the Foundation of the Federal Bar Association. Joey, I knew you'd get a kick out of that one. In this chapter, it's called The Corporation. The corporation is declared to be incorporated and domiciled. You never see that word used. Oh my God. You never see the word domicile. Holy fuck. You got to go back 150 years to see that word. The corporation is declared to be incorporated and domiciled in the District of Columbia. It's the only person I have ever found in all of my research that is domiciled in the District of Columbia. I've seen things where they're like everyone in the District of Columbia literally can't, they're all residents, they're all officers of the corporation. It's like 28 USC 810 or something. I forget that. I'm not going to look that one up. But so permanent resident is the closest to domicile anybody can ever get when it comes to the District of Columbia. You can't domicile in the District of Columbia, and there is no naturalization process to domicile in the District of Columbia. And there's only one motherfucker there. Well, there is, but I've never seen it anywhere where it's, well, they say UCC 9-307H says that the United States is located in the District of Columbia. Domicile means a citizen of. No, we're not going to go down that. That's I'll burn 5 hours and lose everybody. We're not doing that. No fucking way.
Is an individual a minor? Because it said child, it said Negro, child, infant.
Individual, infant, and human being.
Is an individual a minor?
Yes.
Wow.
But then you could say, like, well, what's the definition of Homo sapien? You can go down. Again, it's all presumptions. A lot of these things I think are pretty easy to fight as long as you understand the presumption game, right? So the way I define the word individual is basically the term individual means a Negro and or a non-citizen, non-national lawfully admitted to stay here as an immigrant. Because again, they're a resident if they're in the District of Columbia, and they're also a fucking resident if they're in a state. Resident means alien, basically. That's really, it's just that simple. Resident means alien. Alien means somebody who's not a citizen of that zone. And that's why if you're a United States citizen, you're an alien in California. So they say when you get a driver's license, there's only two different options. There's four total, but there's really just two subclasses. There's a U.S. citizen or a resident alien of California. U.S. citizen means somebody who has put their subjugation into the District of Columbia, and they're in California as an alien. The word resident alien means just, we don't know where his citizenship is, but it ain't here, brother. It ain't here. Another way you could say it is, he ain't white.
So is it like a person who's passing through? If I'm passing
Yep, could be.
Texas,
Could be passing through, yeah.
I'm a resident of Texas.
Yep, could be, yeah. Now the thing is, if you're native born and you're white, you're domiciled whatever the fuck you're at. Naturalization's got nothing to do with you. If you move to Florida, now you're domiciled in Florida. You are now a citizen of Florida. And you say to me, well, Brandon, do I need to tell anyone that? There's no one to fucking tell. Go tell the fucking local butcher. It's the same shit. Tell him. It said in the Naturalization Act that you have to go to a common law court of record. That's where you're supposed to go. The answer is, where do you go? Everybody asks me, where do you go? You go to a common law court of record. And they say, well, where are those? I say, exactly. Good luck. You'll need it. That's why you don't see any of this stuff anywhere. It doesn't exist. It exists, though, but it doesn't exist.
Could we create one?
I don't know. Sure, I don't see why not.
There are groups working on building common law courts around the country.
Yeah, so that would be where you go, right? So, let's see here. What time is lunch? Okay, good. We're gonna speed this up a little bit because I don't want to keep you guys for lunch and shit too much. I got more, but we're gonna speed it up a little bit. So the Incorporation doctrine. The Incorporation doctrine, essentially, and we're going to speed this up. You guys can look this stuff up on your own, right? The Incorporation doctrine is basically, after the Slaughterhouse cases, there was this whole list of cases that started incorporating all of the original white man's state citizen rights back into the U.S. citizen category. And we have all these different cases and all the specifics as to when every single amendment and every single subsection of each individual amendment was essentially incorporated back in. Some amendments have not been incorporated back in at all. Some have been partially incorporated. And you can see that list here. I got all this right off of Cornell, right? And then you even see this talked about in a case in 1908. Thus, among the rights and privileges of national citizenship recognized by this court are the right to pass freely from state to state, the right to petition Congress for a redress of grievances, the right to vote for national officers, the right to enter the public lands, the right to be protected under violence while in the lawful custody of a United States Marshal, and the right to inform the United States authorities of violation of its laws. The right of trial by jury in civil cases, guaranteed by the Seventh Amendment, and the right to bear arms, guaranteed by the Second Amendment, have been distinctly held not to be privileges and immunities of citizens of the United States, guaranteed by the 14th Amendment. So they've been talking about this shit for a long time. For whatever reason. I don't know why. It's fucking stupid. So what's the problem here? You say to yourself, oh, Brandon, well, these have all been reincorporated, so things should be better. It shouldn't be so fucking bad out here. Yeah, well, let's go back to Mr. Tanny. Let's reread one of the quotes that he says in Dred Scott versus Sanford. The question before us is whether the class of persons described in the plea and abatement compose a portion of this people and are constituent members of this sovereignty. We think they are not, and that they are not included and were not intended to be included under the word citizens in the Constitution, and can therefore claim none of the rights and privileges which that instrument provides for and secures to citizens of the United States. On the contrary, they were at that time considered as a subordinate and inferior class of beings who had been subjugated by the dominant race and, whether emancipated or not, yet remained subject to their authority and had no rights or privileges but such as those who held the power and the government might choose to grant them. All these incorporated rights, and well, not rights, that's totally not. These reincorporated privileges are optional at all times.
So that's like real ID, is to suck you into the federal and convert it from a state right into a federal privilege.
It's to suck you into this whole bullshit. So you want to know the only right of a U.S. citizen? There's only one case I've ever seen talk about it. So that's somewhat of a recent case, 1968. United States versus Valentine. What's the only right? Meaning not anything they can take away. So they can't grant it and ungrant it. They can't fuck with you with it. It's not optional. What's the only absolute right of a United States citizen? Here's the quote. The only absolute and unqualified right of citizenship is to residence within the territorial boundaries of the United States. A citizen cannot be either deported or denied re-entry. That's it. You don't have the right to fuck. You don't have the right to take a shit. You don't have a right to drive a car. You don't have a right to drive or travel. You don't even have a right to fucking exist or breathe. Because technically they can put you in a fucking cell, as long as that cell's in the United States of America, perfectly legal. They can't put you in a cell in Brazil. That would be violating the rights of a U.S. citizen. But if they pick you up and drop your fat ass in any prison in all the United States of America, perfectly legal. As long as you're within the territory, they can't deport you. And they can't deny you re-entry either. That's it. Those are your rights. That's your right, single right.
There's some schools of thought out there that think that the CFPB is the greatest thing in the world. I'm kind of with you. Anything that I've ever filed against Experian, Equifax, and TransUnion, it's kind of funny when you log in and they have drop-down menus for a lot of the people that you're making complaints against. That tells you something right there. So, yeah, I've not really had the CFPB that has done much more for me other than it's helped me build a file of evidence. So, right up there with them, you know, there's a lot of people, and I think I see a lot of people teaching from the CFPB thing, and I get it, but there's a lot of statistics, and I think it's important for all of us to file those type of complaints and stuff, and there's other judicial complaints that maybe we'll talk through as well, too. I think that's huge as far as us being able to move the needle. But the CFPB, they do keep stats, and that's where when they come out, the FTC will file a complaint against Experian or Amex or whomever that will be. You'll see that. If you actually did a keyword search now, you'll see where the CFPB has levied fines against Amex for $90-something million. So I think maybe not you and me, but I think a lot of us, if we continue filing those complaints, I have to think that the FTC, who controls them, is going to pick up the ball at some point and pound them. So, yeah, to answer your question, I've filed a lot of them, but to go along with that, like a close cousin of the CFPB is I usually do a local BBB complaint as well. And in the Snap-on case, that's kind of what I did. I'd filed it in Chicago because that's where their headquarters was at, and then they answer in to the BBB, and they usually spew out some dumb shit that actually helped me from an evidentiary standpoint. As it relates to business credit, they're literally telling me, hey, Mr. Kimbrough doesn't know what he's talking about here. This is a line of credit that's not to be used for business, blah, blah, blah. So then why is it on my personal credit profile? Dumbass, you just gave me everything I needed kind of thing, you know what I mean? So, yeah, I use them for what I think that they're there for, is to help you and I file complaints and just kind of keep a record. I think there's a lot of people out there that are utilizing those agencies thinking they're going to be able to file a complaint or file a magic letter, as we refer to it as, and everything is going to go away. And I can honestly tell you, I've never seen that one time. And any time that I have seen anybody that's moved the needle there, and I was in credit repair for a long time, and you would think I was the second coming if I went out there and I had everything removed. Because technically, if you read 15 U.S.C. 1681, if while it's going through to verify whatever it is you and I are disputing, they are to remove it off. So it may be off for 3 or 4 or 6 months, and then, oh my, it just went back on, and now Joey scammed me kind of thing. You know, that's how people will come out swinging. So, and rightfully so in some instances. So I use those agencies for nothing more than establishing and building up my evidence file 100%, because I'm going to take all of that into the litigation arena, man. I mean, I've not seen anybody that's had any luck that's filed into the CFPB or the BBB or anything with a B in it, you know, that's been able to make it stick. So, yeah, that's good. Good question. So I'm going to go ahead, maybe just kind of just run out maybe the timeline and the process on what I did from Snap-on. And you know, if you get Pacer, I would recommend that highly, as Brandon did. You can log into the Southern District of Indiana. You can type in as a keyword Kimbrough v. Snap-on. Or you can type in Branyan, B-R-A-N-Y-A-N. It's actually on Brandon's site as well, with the cause number, Branyan v. Experian et al., and you'll see both of those cases. And then the one I had with Snap-on, a lot of the stuff that I'm going to talk through, you're going to see the documents and stuff there too. So I didn't hide anything. I actually put all of the dockets in as exhibits because I wanted them to be on the record. So a lot of the stuff that you're going to hear me talking about, you're going to say this doesn't make a lot of sense, or maybe you take it away and you have to think about it and put your head around it. But you know, I'm all about on the front end, as Brandon found out, is I'm 100% about the evidence. You know, the procedure even bows to the evidence. I think without evidence, it's really just blabbing, it's hot air. So the way that I do it, and I was telling some of the young ladies a little while ago, and that was actually good that I talked to them, because I probably would have skipped this step. Now there's a site called Identity IQ, not affiliated with them either, it's just the platform I use. Identity IQ, they have a $1 7-day trial where they'll kick you out what's called your tri-merge report. It's all three. So you'll get Experian, Equifax, and TransUnion all side by side. I love that. I've never looked at a credit report, ironically, from an Experian, a TransUnion, or an Equifax. I've never looked at one. I use that predominantly for everything. So just to kind of prepare yourself for, as I told them, they're going to tell you that it didn't come from Experian. You know, it came from a third party, which is the irony in that is, too, is I argue this when I'm arguing about LexisNexis, and here's a third party. But the thing that you have there is a counter argument. I won't go too far down this, is they have what's called a token, and for them to be able to pull your personal credit information, they do have an account with Experian, Equifax, and TransUnion. That's super important to know, so that if that argument ever does come up, you have the rebuttal there ready in hand to say, hey, here it is, prove that that's not the case. So what I do, it's going to sound so simple and crazy, is I look through every account, capital ones at the top, whatever, and I'll look at every value. So there's like 9 different keywords on the left-hand side of variables that they take. Date the account was open, date of last payment, credit limit, top, stuff like that. There's like 9 of them. And I look across the 3. And any one with my highlighter in hand, if I were doing this for you manually, when I find one, I highlight it all the way across the 3. That right there is enough grounds for you to get the entire account removed. It truly is, and it's hard to wrap your head around that. Because what 15 U.S.C. 1681 does, and I'm just going to take that all of you guys are going to read that. It's not a hard read. 30 minutes, you'll have the entire statute read and then go through it 2-3 times. It clearly says that there have to be mechanisms in place to ensure maximum accuracy. That's the one I went on right there every time. That is that's the sentence. Maximum accuracy. How in the flip, if Experian says 1,000, TransUnion says 1,500, and Equifax says 2,000, how is that maximum accuracy when you have 3 different values? The one I usually see all of the time is the date the account was opened. TransUnion's always off. So there's always 3 different dates on when it was opened. And this sounds really trivial, but it's 100% how you get things taken off. It truly is that easy. Now, I'm making it sound more simplistic than what a lot of you guys are going to face when you take this argument into the courts, which is why we need to keep going all the way forward. But I literally will do that for every account on there, and I can promise you that I'll get 100% of the accounts taken off just for that if they're not serving me. Now, what do you mean by they're not serving me, Joey? So I know enough to know that if I have a $10,000 credit limit on my Amex card and I've got $8,000, I've got an 80% utilization rate there. It's not serving me. So then there will be people that will argue with me to say, well, I've had that card for 10 years and Ted told me that the age of the account matters. And it does matter, but it also matters more so. The one that I find that kills you more than anything is the utilization rate. So you have to go through that battle in your own head to say, hey, age is horseshit compared to utilization. If it's not serving me, I'm getting rid of it. And most times you'd be pissed at me because I'd get rid of all of your shit and literally rebuild you on up. And if your lifestyle matched the 817 that I gave my son, then you're fine. Now you're gonna hear people say that they want to see historically what you've done, credit, and all of that stuff. But I think what I've found most of the time, 2 or 3 accounts are going to be left standing that are going to give you some historical backing from a credit standpoint, and that's really all that I've seen that you need. I wouldn't tell you to wipe everything out, build it up if it didn't work. So you also have to step back and say, what is it that I'm wanting to use my credit here for? Is it something that I'm looking for? Am I wanting to purchase a house 6 months down the road, which is typically what I run into with most people that talk to me. Am I wanting to buy a car? Those are the 2 things. Personal loans, other things. But yeah, you can literally get anything taken off your report. And that includes student loan debt. That's a big one that I face a lot. Medical debt, whatever it is that's on there that's reporting out and it's not maximum accuracy is gone. So I'll write the first letter based on that. And one of the young ladies asked me, do you include that with the letter? Yes, I include that just like I would in court as an exhibit, because I'm the guy that wants to lay all the cards on the table. Again, it's good faith. I want you to know everything that we're talking about if you're one of the creditors. I'm sending it to the creditors, and I'm also sending it to the 3 credit reporting agencies, this letter that I'm developing right now. So I'm listing out everything that I found on there where all of the mishaps are at, and I include the highlighted document I made a copy of with that first letter saying, here's where we fucked up. Here's where you're fucking up. So they get that. And then I think you probably can guess what's going to happen there, right? It goes to a system called eOscar. The 3 of them, they bought in together. It's as crazy as that is, even though they're competitors. So eOscar will take your dispute letter that's created. Now, there's a lot of theories there in that community as well. Write it out in crayon, write it out in pencil, whatever, cursive. Horseshit. I've seen all of that tried. It doesn't work. So just stick with the facts, put it in there, let them kick out your eOscar section, whatever they call it, 20 dispute verification kind of thing, because it's going to happen. They're going to kick it back and say they verified. They didn't verify shit. They just kicked this back to throw you off the trail. So that's 30 days. If you look up the statute, which you'll read, you'll see that when you send it across pursuant to 1681 S2, it's telling you the creditors have to do this, and 1681 I tells you the credit reporting agencies, I almost said bureaus, have to do it this way. So the creditors have to report out to the credit reporting agencies within 5 days. You'll see is the statute. Let you guess if that happens. And then the credit reporting agencies are supposed to report back to you within 30 days of the results of your dispute. You're going to get some horseshit canned response back that says it's been verified, not much more than that. So either way, you're just stacking up the evidence. So I just create a folder, I put in whatever their response is, and then I send the second letter. The second letter that you'll see if you get on Pacer and you look at the exhibits that I attached, which I'm telling you, there's your cheat code. You'll see that I sent a second one out. Now I'm putting some statutory language in there. I'm saying, hey, 1681 O and N tells me that I can go after actual damages. I'm playing dumb now. So if you knowingly and willingly are reporting out this stuff after I told you, so I'm putting in the statutory language there along with, I'm telling them on this date I sent you the first letter, and Melissa Moon signed for it at 9:34 a.m. I go into that level of detail. Certified signature number, blah, blah, blah. So I'm letting them know I sent this to you before. Here it is again. Here's the statutory authority. This is number 2. And please fix it. Let's be friends. So I'll give them my request for remedy always at the end of that. Again, I'm trying to help my brother out here. That's what we should all be doing. Get the shit off my report. Because again, it's my report that you're playing around on right now, thinking you're going to control things. So that's going to come back, and you're going to get the exact same horseshit response. It's been verified, go away kind of thing. They're going to continue doing that. So right there at that second letter is where I would tell you something that a lot of, on the bar card side of the equation, would say I'm a little bit off for. This is where I go and I prove damages. Now, I talked to a Chicago attorney who was a consumer law attorney who told me this is what he would call it, testing your credit. I like that. That's actually good, so let's use it. So this is where I go out and I test my credit. I'll go apply for that $50,000 car note or whatever that is, whatever my lifestyle will handle. Keep that in mind too. So when you get that denial letter, and you went to Joey's car lot, you'll get the denial letter. I have to, within 30 days, disclose to you who I used, Experian, or whoever, and why you were denied. And you'll get one from them as well. It's going to say, hey, we pulled your stuff for Joey's car lot, and we used Experian, and here's what you had, delinquencies or whatever it is. Your bill, man, that's like the best day in the world. Because you just told them twice before that those delinquencies aren't real. Why are you still reporting these things? Now you went out and you got actual damages. You went out and you applied for something after you told your brother twice to fix it, please, I'm being kind, and he didn't do it, and now you went out. For me, it was a $2.5 million loan, so it gave me a little bit more big stick, whatever you want to do, $50 million loan or $500, doesn't matter. Whatever, you're just trying to establish the evidence. So I would, even whether I'm going after damages or not, I would recommend you do that anyway because it gives you the leverage. It gives you the leverage to be able to negotiate. So at that particular point now, I'm sending about 15 days later, I'm sending the third letter. I call it, and Cam actually referred to this too, which is cool. It's nice to hear this, notice. Notice of intent to sue. That right there is what the judge wants to see. He wants to know that you told your brother you're getting ready to sue his ass off. Notice of intent to sue. So what do I do there? On the first date, I sent you this. I just recap everything that I've done. I sent you this, and I told you you were screwing things up. I sent the report. Here's a copy of that again, where it's screwed up. The second one on this date you signed for, certified signature required by such and such. I put the name and the whole bit. And you signed for it, you didn't change anything. And on this date thereafter, I had these damages. And now we've got something. So what I did there is I sent them an invoice, them being Snap-on. I sent them an invoice at the same time. And I said, look, let's just be friends. Just give me 30 grand and we'll be friends. Get the shit off my report. The funny thing about this is they actually sent me a letter there after knowing they were screwed. And they said, we took it off your report. It was too late. It was too late. I'd already made my mind up. I had everything I needed. I was going to file. We were going to test this out. So in good faith, I think they were trying to come across, but it was already too late. The damages had been established and all that other stuff. Now, one thing I didn't do in Snap-on that I would tell you to do in version 2.0, Joey, is something I do now, which I'll add a default notice, an administrative default notice. So I'll go through exactly what I'd done beforehand. Just like I said, it sounds repetitive, but it's necessary, trust me. And I let them know on this date you administratively defaulted, because that becomes important at some particular point. So then I established, like I said before, and you'll see it on there if you look in, that's where I went to the table and I started drawing up the complaint. And all I had to do was take everything that I just did through those administrative letters. That's what the importance of these things are. Now, I told my friend there a while ago, I also filed a CFPB complaint. I left that out just now because we'd already talked about it, and a BBB. So I had not only the letters, but I had a couple of administrative agencies outside that I'd sent stuff to. You can send it to whomever you want to. You can send it to the Attorney General of your state, whatever because they do have a consumer law division. I mean, I've seen people do that, and now they'll reach out to you and try to handle it administratively as well. So, however you want to find your way is great. But I'm telling you, what's worked for me is that particular process, not method. Thank you. So I sat down, I developed the complaint based off of that information, but what did I do? So I named the parties: Joey, Snap-on, Equifax, Experian. Those were the parties. What I did yesterday, I told you exactly how to fill out that civil cover sheet, which that's going to be the 3 components you're going to file into the court. So I'll tell you those real quick. The civil cover sheet, the complaint, and the summons for each one of those defendants. Those are the 3 components of what you have to file in the case. Any one of those 3 are missing, it's gone. The civil cover sheet is nothing more, which it's on the website. You can see that at the federal court level. Is nothing more than a cut sheet for the clerk. It's really super simple to fill out, but you just put down, I'm suing them pursuant to 15 U.S.C. 1681. It's a federal question, blah blah. So in the complaint, now I'm back to that. I'm filling that out. I'm handling the jurisdictional component. It's a federal question pursuant to, and look at my stuff, just emulate that 100%. And then I look at the parties. I pull off their information on my state website, Secretary of State. So I look up where's the address for Snap-on, where's the address for, who do they use? They usually all use CT Corporation. You'll find that. I don't care what state you're in, it's the same one, or CSC, one of those 2. And they usually have an office in a big city somewhere in your, so for me it's Indianapolis. So every one of those are in CT Corporation. So I'm literally serving all of them at the same address in Indianapolis, Indiana when I'm sending the summons out. But to file that complaint that we built, and I truly don't want to go through that too much. I truly think you can log into Pacer, pull my stuff off, and by all means, email me, call me, whatever you want to do, text, and ask me any questions you have about it if you want to build this out. If not, don't. But, there's going to be some stuff, there's no doubt that I leave out. But those 3 things, that if you file those into the court, I can just about guarantee you're going to be successful if you set it up the way that I'm telling you to do it right now. Because they really don't have a leg to stand on. So if you file the proposed summons with the clerk, you have the civil cover sheet, and you have the complaint, and you file those. It's $405 at least in my court, with those 3 things. Then what's going to happen? What that's going to initiate is that's now going to initiate. The clerk is going to step in, and here's where a lot of people make mistakes: is they'll start sending shit out because they get cockstrong happy and they want to mail stuff out as fast as they can. Wait until the clerk stamps it and signs it and dates it. That's super important because it's not valid service of process without those components. So it's usually going to take about 7 days from start to the time you file it for the clerk. If you don't see it within 7 days, just give them a call. I've done that before. Said, hey man, I filed a case, it's been docketed, what's up? And they'll say, oh, sorry about that, yeah, we missed. Whether that's to throw you off, I don't know, but I'm telling you, so now it's not going to throw you off. When you have that, now print out your complaint from the docketed site. It's going to have the cause number at the top, which is beautiful. Print out your summons for each one of those defendants. And then I've changed directions, so now you're getting 2.0, Joey, which is going to help you, is I use ABC Legal. No affiliation with them, so I can talk pretty freely. It's a process server that I utilize. It costs me about $75 to serve them. They handle everything, and then they kick me back an affidavit, usually within about a day. So from there, after they've been served and I get the affidavits back, now I'm filing, as you'll see in my case, what is called a notice of service of process. You can use mine. You can template my stuff off of that kind of stuff easily enough. So all I'm doing there is I'm saying, hey, I got an affidavit from ABC Legal that CT Corporation, who is the registered agent for Snap-on, was served, and I'm just putting the address and all of that stuff on there. It's super easy. It's not hard. Now, when that happens, and you tell the court now that they've been served, and you turn in that notice of service of process, now they have 21 days to answer, or else they default. So that's the important thing. That's now at that particular point, you're going to see people start filing in probably within the next week or two. And what I do there is I usually reach out pretty quick after that. Like in the instance with the Snap-on attorney, I reached out right away. Hey, Mr. Kern, I see you filed in. I want to find an amicable resolution for you and me, your client and myself. And I think that's that good faith that I'm always looking for and trying to show them I'm not a soft sit or an asshole, because that's exactly what they usually deal with. And I truly try to show them the kindness that not necessarily is always given to us. So when I reached out to him, it was immediately, he said, yeah, man, I'd love to talk to you, which it started the conversation. Now, as you can imagine, we didn't agree on shit. You know, it was worse than me and Brandon agreeing on stuff. We didn't agree on anything. At least Brandon and I agree on most. So they're going to try to throw you off at every corner. They're going to tell you your complaint's horse shit, whatever it is, but it's there is where you need to stand firm. You know, it's one of those where I'm always told, we're going to get this thrown out, Mr. Kim. There was no doubt about it. You know, you're not. Well, and I've coined this phrase that I use with Brandon a lot. You know, Mr. Kern, we're just going to have to agree to disagree on a lot of things. And that pisses them off, but that's like kind of slap in the face. So when you do that, what happened is they thought that I owed them $7,500. You guys have the same thing. If you have credit cards, whatever that may be, they think you owe them some type of money. They thought that I owed them some money off of a tool that I'd given them back in good faith, and here they are killing me on my report. So anyway, the conversation had at least started at that particular point. And if you truly look at my case and what I were trying to do there, you'll see strategically I did something. I let the first one out for a little bit. I do that with all cases that I do. So for instance, Equifax is the first one that I had the conversation from, that I sent what is called a 408 offer and compromise. And if you're looking at the federal rules of evidence, and I recommended those 4 pillars yesterday, the rules of evidence were one of them. Rule 408, just as Brandon showed you 301 today, 408 will tell you exactly that any conversations you have in that offer of compromise is what I'm calling it. It's confidential settlement communications that are not admissible. So here's where you can talk about pink elephants or assholes or whatever it is you want to talk, and they can't use it against you. So that's when you send it over and you say, hey, it's called a settlement demand. So at the top I'll have 408 confidential settlement communications or something. And then I'll just go into, because that's what they'll typically ask you for, send me my settlement demand. And if you're like me, you're like, what the hell's even a settlement demand? So I'm trying to cut through that for you. So here's where I'm telling you all of the relief I'm going to give you. Now, I'm also listing on there all of the evidence that I've compiled so much. They've already read my complaint, but they're trying to feel me out to see if it's bullshit. So I let them have copies of anything I have before they even ask for it through discovery, because they know I'm going to do that. So I'll send them everything I have. I'll also send them, here's what I'll take. And this is why I've been so successful for those that I've helped in the past that aren't looking for damages like I was, because that right there is the point where if all you're asking for and you do have legitimate damages, i.e. you've been denied something, it's like a godsend. The heavens open up if all you're asking for is to take all the negativity that I said was on your report. Take all of the counts that are not serving me, and I'm not asking for 10 cents. So when you do that, it's a no-brainer. They're going to say, hey, here's what they're going to say, send me the stipulation of dismissal, I'll get it signed. And then they're going to send you back a settlement claim that's going to be an NDA that you're going to sign that says you're going to release all claims against Snap-on whomever with prejudice, meaning you're not, from that date back, you're never going to bring any claims for those things again. And that's really I think that's a pivotal point right there for any case, man. If you're the one that wants to just get your shit cleaned up, right there is when it happens. And you're literally a couple of months into this thing. So I've said that a couple of times. Mine took 10 months. I got 34.5, and I also got an 839 credit score. 5 of those months were from me being an asshole. So I was just wanting to test the process. At 5 months in, you'll see where I added 5 more defendants. It's where I'd had to get a hearing established because me and the attorney were fighting. I was going to sue the CEO the president, and 3 board members, which I did. So now I've got to, here's what happens in that instance, and I would not recommend Joey version 1.0, is now I've got to file now, basically, it starts it as a new complaint, because I have to go now get 5 more summonses for each of those individuals. Once those summonses get stamped, signed by the clerk, then I've got to send those off just like I did the first go around. It's just, I would never do that again. I just get it all out of the way at the onset. But it's one of those things, ego, and he said I couldn't do it kind of thing. It was like, hold my beer, watch this, you know. So we had the hearing, the judge agreed with me and said, yeah, why not? You can always put in a motion to dismiss and see how good you are. So they didn't. We joked about it. I called him, and he's like, hey, what's up? You should be adding me to your Christmas card list right now. Just 5x your retainer, Mr. Kern. Well, there was a lot of overlap, Mr. Kimbrough, but yeah, we did okay. You know, so I'm establishing that I know the game with you, man, and you should be grateful that I just popped 5 more of your people. So anyway, that just kind of opened up the process, but you'll see right there at about that time is when I submitted or filed a stipulation of dismissal for Equifax. I got $2,000 is what I settled for with Equifax. I've not told anybody that. I'm telling you guys, I mean, the exact numbers. So $2,000. I released all claims. They took everything that's on my Equifax credit profile off that I didn't want on there. Remember, I talked about all that stuff earlier that you can take off anything you want. That was the point where it happened. So they sent over the NDA, where I'm not supposed to be disparaging them and calling them assholes right now to a group like you, which I'm not. And all of that stuff we got out of the way, the formalities. It's what you hear referred to often, which is ironic because you never see it. It's dotting the I's and crossing the T's is supposed to happen there because they never dot I's or cross T's, if you know what I mean. They screw everything up. So we agreed, $2,000. They took everything off. My Equifax credit profile went up overnight. You'll also see on that docket, 2 weeks after that, the same thing happened with Experian. You won't know what's going on unless you were physically talking to me as you are right now. You'll just see that there were filings because you don't see the behind the scenes. You'll never see the settlement agreements. You won't see the NDAs. That's the stuff that we've hidden from you off of the docket. You'll see that there was a stipulation of dismissal where Joey Kimbrough and Experian's, his name was Bo Stewart from Jones Day Attorneys, signed on their behalf, $5,000. We started at 10, and they talked me down to 5, or I guess I agreed to 5, however you want to look at it. But now here I am, June 22nd I filed it. That's about mid-July, so I'm about a month in. I'm $7,000 up on a $400 investment of something I truly said I wanted to try. So it's a pretty good business investment at that particular point. I had nothing to lose with Snap-on, so now we have the next conversation, me and Mr. Kern, and here's where he starts. You let the wrong people out of this, Mr. Kimbrough. You should have kept Experian and Equifax. And these are the things that you guys are going to hear that I can't tell you enough, that this is all horse shit. It's like, I immediately came back with, no, I got everything from them I wanted. What do you mean by that? And now I'm not sharing numbers with him like I just did a crowd. I'm telling him that my credit score with one of them went up to 839 and the other one went up to 828. And right then he's like, oh, fuck. We don't have to talk about numbers anymore. They gave me all the intangible benefits that I could ever want. Now it's back over to your client that did the real damage. Now what are we going to do here now? So that's when the horse shit stopped, kind of. But that's when it was like, well, you know what we're going to do for you? We're going to forgive that $7,500 you owe us. Man, it's when you guys will become crazy people at that point because you're going to say, it's real. It truly is real. Numbers and things are changing in my life, and you're going to be as hooked like a crack addict as I am and interested to talk about this. So at that particular point, when he started negotiating with me, I knew that I had him. But I wasn't going to let this thing drag on forever. There was a lot of things that were going on. And as the conversations progressed, we got up to, well, we're going to waive the $7,500, and we're also going to kick you $2,500 back. And then after that no right there, again, he was training me, and he didn't realize it, but he's what kind of taught me this entire process. He came out with, let's just do a settlement conference. What do you think about that? I'm going to tell you guys, I didn't know what the fuck a settlement conference was. But I'm like, yeah, man, let's do that. Yeah, what's up, bro? So anyway, he filed it. We have a hearing in front of the magistrate judge. And what a settlement conference is a Zoom call. And you have to, 21 days before that settlement conference, you have to do your last and final, which each side wants. And you have to, and for the equity folks and all this, you'll understand, and this is kind of where this ties in, I think, is everybody that's there has to be able to write a check. We're going to get this shit done today is how the judicial system, don't bring me some flunky ass that's not going to be able to sign a check. Well, I can sign a check. Joey can. He's a party. Snap-on sure as hell can sign a check. They're $1 billion corp. So we were there. We show up at this date. And before that, that's when, I mean, I could show any of you that are interested what my final looked like if you ever got there. But that's where I turned in presumptions, and I'm saying this jokingly, but I really did turn this shit in. Can't get a hard on, emotional distress, all that stuff that equaled 16.75 million. I mean, my man's laughing. So it's all horseshit, but what is Kelly Barr, the woman magistrate, going to do to prove that presumption I just launched across? Well, you need to come down to Indy. I need to test that out, you know? And I don't think that's going to happen. So there's really where, you know, all joking aside, that you can put over anything you want. I put down lost auto loan, business stuff. I had everything that equaled 16.75 million that, again, it's mine, it's real. So I'm telling my story here kind of thing that I gave her. I don't know what Snap-on put across, but I know we showed up on the date we were supposed to. I'm sitting in front of my laptop. It's a Zoom call, and there's 4 boxes. Kelly Barr, magistrate judge, you'll see her name on there. Mike Walsh, who was the dumbass that answered the CFPB and the BBB complaints, who was a senior vice president. I probably shouldn't say dumbass. There's that. It's not disparaging. That is a gratitude thing. And then you've got me and you've got Joe Kern, the attorney for these guys. So what happens in that settlement conference, if any of you guys ever go through that, and I hope you do, it's one of the most enlightening experiences. I know Brandon's working his way there, and I know he's going to get there one day. This is part of the discovery process, is they'll start breaking you up into rooms, as they call it. So the first go-around's all 4 of us, and hey, guys, how are we going to settle this? After she pumps herself up, she being the magistrate, on how she's won all these awards and blah, 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 that we don't give a shit about. And she's a master negotiator, all of these things. Okay, great. Let's see it in action. So we all talk. We really don't reach any resolution. Okay, great. They put them in a room, and now it's her and I talking. So what is it really going to take to get through this today? And I tell her, and I can't remember what the number was, but then I'm in a room by myself, just sitting there, and she goes to them, and they're talking back and forth. Who knows what they're talking about? I can only imagine. And then they come back to me, and we did this for about an hour and a half to where all 4 of us pop on the screen again, and it was, oh, hey, we're not going to reach a resolution here. We're about an hour and a half into this thing. Sorry, we're going to have to cut it free. 2 weeks later, we settled. We settled on $20,000 is what they sent me in cash. So I got $2,000, I got $5,000, and I got $20,000, and then they waived $7,500. So you add it up, it's $34,500 is what I say I made on that case. You know, so that was really it for me. I mean, Brandon and I have talked about this at length. That would have been one of those, had I built it with my information, it would have went to trial. Now, honestly, I don't think it would have went to trial. It would have been one of those the day before kind of thing. We would have settled. Probably would have been about 10 times higher, because that 16.75 was still out there. So they're doing the best cost. You know, they're doing that stuff. They're figuring, is he going to get in front of these guys? And this is one thing I left out too, that during one of our conversations, you have to really take the energy level down, and you have to really, because I think Quinton actually said this, you get nervous as a whore in church. That's a Midwest saying. But he was nervous, and you just start bumbling shit when you're starting to talk in court and all this stuff. We all do. We just kind of clam up, and we just start saying a lot of stuff. So, you know, when I was talking to Attorney Kern, we just kind of had good back and forths. But one thing that I said to him that I think to this day resonated is I said, hey, you know, if you put me in front of a jury of 12 of my peers, I promise you that by the end of that, they're going to, one, I think they already hate attorneys and they hate banks. We're pretty open, and it's just the 2 of us on the phone, so we can say whatever we want. And he chuckled. because he knew what I was saying was 100% true. I'll wear mascara, I'll cry, I'll put on the biggest theatric event for you in there, but I promise if you're one of the 12 that are sitting out there and I'm talking, you're gonna feel me. You're gonna say, fuck, I got an Amex card in my pocket. This motherfucker's really resonating with me. You know, it's that I will get you feeling my energy. So especially if I have an ass load of evidence, I've told you all along everything that's happening, gonna happen, and the damages that I have, and blah, 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 you're gonna start feeling that. Do they want 12 of you that look like me, that feel like me, making a decision for 16.75? Not to mention punitive damages on top of that, which in Indiana, and I think everywhere, is 4X. So now we got a big ass claim. So they, you know, of course he told me that by them giving me $20,000, my name's on the wall of fame there and they hate my guts and all this. And I said, hey, I wear your Snap-on jacket to this day. I do, actually. I'll send you a picture. So it's not, I have no ill will towards any of these corps that are out there, especially whenever I know where I'm coming from is a place of truth. And this is the reason why I really don't need to put anything up here in as well as this case, because if you go look, you're going to see what I'm telling you. And I can rattle this shit off because I lived it. I know it, and it's the truth. As I know you guys, I've heard a lot of your truths already, but where I see you and me is just you don't really know the process yet. And you'll figure that out along the way, man. Study my stuff. Look at what Brandon's doing. He gives it all away for free on the Williams & Williams site. You can look a lot of my case stuff on his site. So you'll see a lot of everything you need. It's just one, having the confidence to be able to talk to these folks and not be intimidated by them. And then the ones with the beautiful little black dresses is how I look at them over there. I imagine nothing on underneath that, so it gives me a kind of a chuckle. They're actually working for you. And I think something else that's super important here, me and a couple of young ladies were talking about it earlier with my man here actually too, is we don't do enough of complaining, meaning official complaints. I think if we start if we start filing these complaints, and I'd love to talk about that for a few minutes here too. I just filed one, I think we talked about it yesterday, the 28 U.S.C. 351 is that. And if you go read that, it's the judicial misconduct complaint. And it tells you the whole process, and 352 right behind it tells you how the chief judge is supposed to, how they're supposed to handle that complaint. So I think if we start doing that and filing more of those, and we start learning about the judicial codes of conduct and how they are violating laws, which gives us the basis to file those complaints. Because without that piece right there, I did what I think a lot of you guys would do, is just ramble a bunch of horse shit as to how you're feeling at that particular moment when you wrote out the complaint. No facts, no evidence, no law. So if you stay within the lines, I keep calling it coloring within the lines, is just reading what they're putting on the page that they're not going to abide by, you abiding by it, and you cannot lose. I keep saying that, and I say it with all of the humility and confidence that I can muster up. So filing those complaints, that's at the federal level. And at the state level, so at the federal level, the judges have what they think is applied immunity, or absolute immunity, I guess you would say, since they're put in there by a president. I haven't tested that, but I'm sure as hell complaining right now. I just filed one the other day. I sent it to Brandon so he could see it, that got docketed, which is awesome. So it means that there's actually an investigation that's going on. Now, if you're going into state court, there's actually even better stuff for you there as far as complaining. And if you're looking at, and I know I've talked to a lot of you that are having some heartache with city officials, attorneys, city attorneys in particular, what I did is I actually, if I get into a state case, one of the first things that I actually do is I look at the oath of office and the bond. Those two things, oath of office, bond. Where do you get them, Joey? So I sent across a FOIA request to the clerk of the court, who is the county clerk. So if there were 4 people I were going to send it to, so nobody can play fucksy and say that they play dumb, and just to cover my bases, the county clerk is the one that should be kicking you back that information on those individuals who are your public servants. But I send it to the county clerk, who is the clerk of the court. I send it to the city clerk of Kokomo. I send it to the city attorney of Kokomo, and then I send it to the county attorney of Howard County. Those 4 individuals, I want all of the oath of offices, and I want all of the bond informations for my public servants. And then I've got a letter, I could send that to anybody that wants that, that shows you exactly what I said there, what I was asking for, who I was asking. Just take out the names, take out the keywords. Instead of Kokomo, Indiana, your city, Howard County, your county, and then your city, county, or county, city or county officials. And the reason why that's so important is because as you start looking through that, you'll see that they took an oath of office. The bond is the key right there. So if you look at the state statutes on what it says about bonding and having a public office, you'll find out real quick that that's a huge, serious issue. It doesn't sound so, but if you look in Indiana, your state, you'll see that it's anywhere between 8,000 to 20,000 or 30,000, I think the max is on whoever the city official is or county official. So it's not a big deal if you and I just keep our mouths shut and we don't file these complaints. It is a big deal that if I show that one of those public officials had done maybe a judicial misconduct kind of thing, went past the codes of the canons and violated rules of the court and the law, now I have a claim against their bond. That's the key. So if you hit that bond, I don't care about the money aspect of it. I care about the fact that the surety is not going to give them the bond about the second, maybe the third one of those. So I know she's got a group of quite a few people in her area. If all of them got together and started gangbanging, one judge, one mayor, one whatever, you'll bring them back in line and you'll see there's no bullshit. But it takes just a small group of us to do that in our area, wherever you're at. So, if that bond is away, and if you look at the state statute, your state, mine's Indiana, it clearly says that they cannot hold public office without a bond. That's why that's so super important. So the first time that you start that and why that is so important in that process and knowing, how to do that, it's imperative. You're going to bring them back in line. They're going to start listening. They're going to ignore the shit out of you, just like Experian does with E-Oscar and all the stuff we talked about a little while ago in my Snap-on case. They're going to ignore you until they can't. So I think that's super important. Yeah, you got a question?
Is it another thing to do, to remind them of their liability issues, basically what they have, and they're liable, and bring that kind of, into the public domain? Isn't that how they got rid of Como? I think there's a guy that I knew that did that, and it's trying to get the public. I forget what I was going to say, but it's their notice of liability, right, with their fiduciary responsibility, and they take their oath of office. Is that kind of what you do with that? Yeah. Right.
Yeah, so I think that's good. I think that's exactly what happened. Anybody that gets kind of, let's call it, railroaded out, the craziest thing, it's us that does it. When we are the ones that actually stand, their buddies aren't going to do it. They'll talk shit about Nancy Pelosi and these guys all day long, each one of them, and there's shit that's going on there, we know. But until we actually are the ones that have the power to take them out, it's not ever going to happen. And here's what, we'll all talk shit and we'll eat too much food and all whatever it is, however we internalize this through stress, and talk shit about them all day long and then not do anything. So I've kind of studied the process. So that's one thing to do, at least if you're at the state court level. There's also, if you look at the rules, the professional standards of conduct in your state, that was one of the other 4 pillars that we talked about yesterday. If you look at 23, it talks about how to keep the attorneys in line and how to file a complaint against the attorneys. Specifically, it tells you step by step on how to file it with what agency at the Supreme Court of your state. If you look at 25 of that same professional standards of conduct, it tells you the exact same thing on how to file a complaint with the judiciary, i.e. the Supreme Court in your state, for a judge, step by step. It tells you literally. So there's really no excuse for us unless we're just too lazy to not look at Rule 23, look at Rule 25 under the professional standards of conduct, and it literally tells you how to fill the forms out, where to fill them out, and all of that. And what that does is it kicks out a a cause of action, or it actually kicks out a complaint, and then you have a whole group of attorneys there internally at the state level or the Supreme Court that'll actually take that on if your shit's valid. So that's where I think, us talking right now and not blabbing out a bunch of stuff like I used to do in the past is going to get you. I think the last time I looked in Indiana, and I'd love for you guys, and I'd challenge you in any of your states to go look at what I'm telling you, like on the Secretary of State website under the judiciary. So I know in our state there were, I think it was 1,441 complaints filed against attorney and judges last year. And I think about 1,200 of those, if I'm not mistaken, were thrown out. And it was probably a lot of people like me in the past that were just throwing a bunch of bullshit in there. But I think if you made an impact with your affidavits or declarations, however you wanted to do it, of facts, and you truly build something up. And here's another thing. I mean, I just like I steal the shit off of Pacer, I go there and I steal the shit off of that. So if you look on that Secretary of State site, you'll see where the Supreme Court has filed causes of action based off of what I'm telling you to do. So it'll be a real attorney. Ours is called, her name's Anita Herring, I think it is. So I look and I study her stuff. I'll look at how she created the complaint against Todd Rokita, who is our Attorney General in Indiana. This dumbass was on Jesse Walters here a few months ago during the election talking shit about some freaking lady that's a doctor over in Ohio who sent a 10-year-old over to our state who had been raped to have an abortion. This is the freaking Attorney General of Indiana, bro. What's up? So not that I don't care what Ohio and stuff, what the beef is, but dude, you don't get on Jesse Walters on prime time and start talking about how this doctor's a dumbass. He just, so anyway, I wanted to read that. So I went and read how she built the complaint, and you'll see it's so simplistic. I would like for you guys to go look at that. I mean, it's just, you'll see, yeah.
Do you have to be a party?
No. No, that's public.
In front of the court or in front of that attorney, it's public, you can, like an amicus complaint, sort of.
Yeah, so there's got to be a reason why so the question was, do you have to be a party to, I think, file a complaint against an attorney or judge or any of that stuff? You would have to have a reason. There wouldn't be a party necessarily or a cause of action, but if you're having some type of heartburn outside of the court, that's okay too, with something they're doing, driving matters or whatever that might be. I think the important thing is to just get the complaint in some type of an affidavit of fact saying, here's what's really going on. Because as we talked earlier, I think that's where a lot of people make a mistake, and I'm going to try to bring this all the way around, is we'll actually just send over what I would consider a bunch of presumptions, which is what we're met with. The time that we're met with those, we should always be sending across at least a declaration that we're affirming under the penalty of perjury, because here's what's not going to happen. They're going to send you something back, but it's going to be some more horseshit presumptions. They're never going to meet you with the same instrument that they're supposed to, which has perjury attached. I will literally go to prison for what I'm telling. I mean, I would do it gladly. That's where you can take it to the bank that if I'm putting it on the docket and it says declaration under the penalty of perjury, there is no room for bullshit there. I literally know exactly what it is that I'm telling you is 100% accurate, and that is so hard for anybody, especially a bar card, and we know how they operate, to send you something back. So any of the complaints that I've seen from the Supreme Court against attorneys and judges, I love going on there for shits and giggles sometimes just to see who the latest judge was that was arrested for drunk driving, or whatever. One was just in a wreck not long ago. Or it does happen. It happens a lot. So I go in there and I'll just look at the complaints. You can literally file into Indiana right now. You don't even, there's no account you need. You can literally get on our Secretary of State site and see what I'm telling you, and I'm sure your state as well has the same thing. So look at how the person in the Supreme Court is drawing up the complaint. I'm going to go steal her shit and draw mine up exactly the same way, except I'm going to add my affidavit of facts or whatever it is that I have as evidence behind that. And I think that's the important thing for us as we go, those of us that want to continue going down that litigation road, we make it way too hard, way too hard. It's really actually the simpler, the better. But all along the path, you're going to have people that are trying to pull you off of it. I promise you that if you're in courts. There's no doubt about that. I can't say that enough. And until you actually feel it and you live it, Brandon could actually speak to this. He knows 100% that you're usually going to get some type of horse shit that's going to come from them right away to test you. And it's usually low-hanging fruit. When they see pro se filing in, it's like, I got another one. You know, so they know 9 times out of 10, they're going to get your stuff dismissed on day one. It's just a reality, a 12B6 motion. So we the groups that are forming, Cam's group, those guys, they need to be, we all need to be talking about. And here's what I was telling a couple of folks at lunch. Persuasive authority is the key. That's going to be the thing that makes you successful. Now, a lot of us thinks that persuasive authority is 100% case law, and I truly don't want to make this crazy way above any of us. Persuasive authority means nothing more than there was a decision in another court of competent jurisdiction that's something they can put their teeth in. Now, it's not something where they have to, through a discretionary standpoint, recognize something from Florida in Indiana, but they'll look at it, especially if you tell them so. So in my instance, I found a couple of weeks ago, a magistrate in my court in the Southern District had actually sanctioned, this is the AI conversation for any of you guys like me and Cam that use AI. You need to keep this in the back of your mind because this is something you truly need to. So Mark Dinsmore is the magistrate. He's also the one that I just filed the complaint about, funny enough. He went over, and I wanted to find persuasive authority because I'm trying to crack a couple of attorneys, and I saw where 2 weeks ago he had just, because I go research this stuff, I like to look. And I saw where he had just sanctioned another attorney that had filed in, who had filed 3 briefs in one case using AI that hallucinated with bad case law, and that's real. So if you're using ChatGPT, Perplexity, or anything else, it's going to give you Beavis versus Butthead 2001 or something. If you put that on there, you're going to look like a real dumbass. You need to go search and see if Beavis versus Butthead is a real case. So anytime I use it for any capacity like that, I go back and I check on Google to see if it's real first. Then I pull up the opinion from the case. I'll take the opinion back to ChatGPT and I'll start chopping it up with ChatGPT. I'll say, hey, what's up? Let's talk about this case. And I find out if what was said is real. And it'll give you that, whatever you ask. You just need to know how to prompt that. And I see this every day, especially on Brandon's page or any page where we're talking about stuff like this, is folks will just there's one guy in particular on his pages that runs me fucking nuts, and he knows it. And it's just, he'll literally regurgitate ChatGPT stuff. I don't know if he's trying to impress Brandon because he's got some kind of man crush, whatever it is, I don't know. But it's like, you can see it. Like, hey, write me a motion for what? Some type of a stuff. So just be careful and know that attorneys are now being sanctioned. And if you read that, it was actually a pretty cool order. He said, I'm all for technology, the magistrate did. I'm all for using it, but this is not the place for spitting out, especially from an attorney. So right now they're watching the attorneys and how they're doing it. It's going to be you and I next, as they should. We shouldn't be putting stuff in there just as for no reason whatsoever to try to get a leg up. So anyway, that's kind of a very high overview of some of the stuff that I have on. I've got a ton of cases. Brandon has a lot of stuff on his page. Yeah, what's up? Yeah, so arbitration is a place that I think is like the Antichrist. I don't even like to hear that word because I truly do not believe in arbitration. Please don't I know that's not why you were talking about it. I know some states try to impose alternate dispute resolutions, and this is a whole other conversation. And once you get into the courts, some of them, Minnesota in particular, makes you go ADR before they even really do anything. So they want mediation. I'm all for. I think mediation's great, especially any of you folks that are married like I am. If you ever thought about going down the bad path, bring a mediator in. Don't give these bar cards the money. I mean, there's all that horse shit and emotional stuff going on. To give 2 attorneys nothing more than the ability to clean out both of your accounts because you're pissed at each other and you're wanting to end things crazy enough. Don't do that. Mediation, I think, is awesome because it does not have to be binding, which it should be if everybody agrees on. But the reason I hate arbitration so bad is because you give up rights. I do not want to give up any of my God-given rights, especially when it's a retired judge that's sitting there as a mediator that has the power to make a final decision, and it's not appealable. So there's like 4 things that I hate it for, and it's really all I could do. But I think that's a great idea. You know, look at the billables, $5,500. I think the example was for however many hours and all of that stuff. And you know, it's just like anything. Yeah, and then that's when you know, that's awesome. I think that's a great idea, and this is what we need to do more of, you know, because I've given you a few things, and now that one right there, the criminal component, you or I wouldn't take that on, but we would send it to the U.S. attorney in our district, or we would send it, if it's the state level, we'd send it to the attorney general and let them handle that 18 U.S.C. 242 and 241 claims. So you're building all the evidence, and I find that's where I move the needle is really fast, you know, you'll find this out too when you get into the court systems is proposed orders. I didn't even know what the hell a proposed order was in the first case that I went into. There were so many things that I learned throughout the process, but when I heard the judge say, all right, I need your proposed orders, both sides, in 30 days, I said, what the fuck is a proposed order? So I had to go learn what that was, you know. So it's one of those things now where every motion, especially a dispositive motion you put across, you have to have a proposed order. Why? Because they're lazy as fuck, and it actually gets me excited to a whole new level when I see a judge, especially a federal judge, sign the words on the paper that I just put down for them to sign. So you're asking in that proposed order for the relief that you want. If they read through it, they read your motion, they read it, and they say good. You know, so that's really what it is. If you're building out essentially the complaint against the attorney and you send it to the United States attorney in your district, they pick it up or they don't pick it up. But at least you did the front end work. I think that's an awesome way to handle it as well. You know, depending on what it was, they may bring outside resources in, you know, like the FBI. So I'm always testing stuff out. What is it? I can't believe what the Whistleblower Act, whatever it was. So I share this one with you, and this will kind of maybe make sense for some of you folks too. Again, I've already said my wife's an RN. She got a bill a while back for a small procedure that she had done. And it was like $2,500 or something as to what they said she owed. And she like me, it doesn't matter. But there was a lot of fraudulent stuff on that she, as a nurse, looked at and says, I didn't have anesthesia. Matter of fact, I told him I didn't want anesthesia. Well, she got cracked for $800. She didn't. The insurance company did, $800 and something. And as she went through, there was a ass load of fraud on there. So I showed that to Brandon. You know, so I created a complaint under the Whistleblowers Act, filed it in federal court as my wife. I was her. And what happened there is they took it in under camera, I think is what they call in camera. So they basically took the case. The United States stepped in and represented this. So now literally the Department of Justice and the FBI called my wife. Now I already told you how averse she is to the stuff that we're talking about right now. You can imagine one special agent, whatever her pants was, called my wife. And why is the fucking FBI calling me, bro? So, you know, the DOJ and both of them will call. But I think it's important to know that you have the ability to do that. So the United States will literally step into the complaint that you filed, and that's one that's in the Southern District too. You could look up Lisa Kimbrough v. United Health Systems, I think it was, Howard Community Hospitals. So these are real things I'm not bullshitting you about that you can see that they'll come in, the United States will come in, pick it up, use their resources. Now, whatever's claimed there, and the reason for doing this, man, I'm not trying to say that we're sidestepping anything, and I don't want you guys to do that either. But that was fucking fraud. It was literally insurance fraud that was committed, man. I mean, here's my wife saying, just tell me what I owe you. Much like I do in my complaint process with credit, she had been doing some gal named Lalita or whatever, and she was smart enough to write the dates and the times and the conversations of, hey, I didn't have these services. Please re-rack my bill, send me back the right one, just like we're doing with a lot of our stuff. So that never happened. Then guess what happens? Now she gets a letter from a collection company. I'm coming after you, the big bad wolf. Here I am. Well, you know how that was met, and she just happened to be married to a different guy that's touched in the head. So I filed over, as I told you guys a couple of times, and this is awesome, you need to think about this. I can't remember the name of the collection company, but the first thing, as I told you I do, is I look at the Indiana Secretary of State to see if they have a certificate of authority or a license to operate in the state. I'll let you guess that one too. So they didn't. I knew it. I created a letter, 15 U.S.C. 1692. You've heard enough about debt validation. I had that coupled with the fact of, hey, what gives you the authority to even collect this stuff? You know, so there's that whole thing happening outside of all of the fraud claims and stuff that we're trying to build there, which, you know, if they would have sent her across, taken off the claim, she would have paid the $1,000 or whatever it was, and it would have been a done deal. Yeah. What's that? Yes. That's what it was. Yeah. Yeah, that's exactly what it was. So when they filed it, or when I filed it, that's exactly how I filed it. I cannot remember the statute on that, but I'm saying Whistleblowers Act, and there's a statute behind that too. But that's exactly in rem or whatever. So yeah, I know exactly, and it's all done in camera, so it's like off the record. So that if I wanted to step back in, that statute gave me the ability to do it if the United States said that they weren't interested in being a part of it. And quite honestly, I think that's where we got to, and I'm not so sure that if I picked it back up and everybody fucked off and went away, which was my goal anyway. When the shit with the collector started, I said, honey, don't worry about this. You'll never pay this bill. And she had enough confidence in me to believe that. So it's not that we're trying to get away any more than anybody in here is trying to get away with something or sidestep something, but I can show you example. I literally see this stuff at a scale that you can't believe, of stories just like the one I shared you about my wife. And then they'll try to make her the bad person, that she doesn't want to pay her bills or whatever that is, and she is completely unlike me. She's the other side. So she would have probably, but she got fired up. I got her fired up enough. That's really what happened. So I think we need to all do that, hold each other accountable, because what happens? So if she hadn't done any action whatsoever, she probably would have gotten some type of, if she wouldn't have played ball with the collection company, there would have been a trumped up charge, pardon the pun, and then she would have had some type of judgment on her. You know, there's that 1 trillion of judgments that I keep professing that literally happens every year, because we don't know the process, or we don't know how to rebut it, we don't know how to challenge it, we don't know how to dispute it, and we just accept that the defaults that come across to us. She would have at some point, had she not dealt with it, if she would have been version 1.0 of me, probably would have gotten some default, and that's sad. I think that happens a lot with a lot of people that just don't really understand how to, and I can tell you do, because you're asking all the right questions. It sounds like you do a lot. It's great. There's a lot of people in here I know that are really starting to challenge and dispute and take stuff on and create arguments in their own processes. I'm just kind of sprinkling in the part about, I think it's important to start doing the judicial complaints. I truly do, and I'm starting to do them myself, because to be honest with you, I've been a little lazy on that. Once you get in and you start getting sweat and beat up and bruises and stuff like that in the court systems, to even think past that nonsense that's going on, to say, well, now I need to step in. But really, I think that's where it's at. I think that if they see your name pop up 5 times and then they know you're going to have 5 complaints against them, I think they are going to start operating a little bit different when they see your name. They're going to start respecting you, me, a little bit different. And I think that's where it starts. It truly does. I think if we just keep ignoring what's going on to us and allowing them to get away with it, that's where, you know, it'll continue. So, yeah, that's just kind of my 2 cents. So, and yeah, what's up? Certificate of authority, or if you have a license to collect debts in this state. Yeah, it's one of those 2 things. The Secretary of State. So I'll ask them for it, but I'll go to the Secretary of State already knowing the answer. So like I said yesterday on one that I had in the past, I think it was Commercial Collections of New York was the name of the company, from Tawanda, New York, wherever the fuck. So I immediately jumped on the Indiana Secretary of State, typed in the keywords commercial collections of New York, and they weren't there. So when I knew that, I already knew the answer of what it was I'm asking them. I just wanted them to confirm, which will never happen. So I sent them that debt validation letter with, hey, bro, send me the certificate of authority or the license that you have to collect in this state like you say you can. And you'll find that a lot of the horse shit that comes at you is exactly what I'm telling you right now. They do not have the authority. It's usually just one company like an Amex that'll hire somebody carte blanche and wear BFE that doesn't have a license for every state, or they're just too lazy to get it, or it's not something that you. So what happened there is when I sent that letter, I think that was April of 23 or something like that, I never heard another, it went away. So I think that's an awesome way to get some of the stuff going away. It's kind of like Cam was talking about yesterday with the injunctions. I understand injunctions. I think it's great and temporary, but that's in the court. This is kind of outside of the court, you know, to get them to stop the nonsense, is to show them that you actually know what's up. Once you get in, now you're doing the TROs and the injunctions, but outside of that, how do I get them to stop the nonsense? Or the calling my employer, which is a big no-no with 1692. That's another one. If you read 15 U.S.C. 1681, which if you were partying with me, we would be talking in that language. But I would say another one right behind that would be 15 U.S.C. 1692, and that's the Fair Debt Collection Practices Act. So that one is that's the one that most of us have the heartburn with when they start calling your employers, your abode, your place of employment, blah, 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 talking to anybody maybe other than your spouse. Huge no-no. Huge no-no, man. So they cannot just be, and that's happened, you know, where I've seen them call employers, and that's where I've seen a lot of money change hands, is with that one right there. They'll call you out. I hope there's no New Yorkers in here. I love New Yorkers with all of my heart. I truly do. But that's the one, man. They call up with some game. You know, they'll curse you. They'll do all kinds of stuff, especially if you're a woman, to intimidate you and all of these things. And that is clearly spelled out. Congress needed to put that in words, which you'll see when you get in and read what I'm telling you. It's in there. There's none of the cussing. They only have between certain hours of the day that they can call you, and I promise you that they're not doing that. It's like business hours, 9 to 5 or something like that. So a lot of times they'll call you at 9 o'clock or on a Sunday. No. Log it, man. Create that evidence file. You know, I've seen literally hundreds of thousands, if not millions of dollars I've heard. These are ones where I always ask for receipts, but the hundreds of thousands I've seen, 150 to be exact, where somebody will curse some lady out, gets into court, they've got everything documented, maybe even a recording, which I would definitely recommend. Even if you're not in a two-party state, whatever it is, some states you got to be really careful with that. You know, you got to get consent. But I'd roll the dice on that one. I record everything. If it's some number that I pick it up. I love talking to people, man. So just record it, you know, and I think that's super important to build your evidence file, man. So yeah, I love the questions. And I know we're all going through this together, and sometimes it's hard to wrap your head around it, but I think the more that if you're interested, kind of get in the weeds, there's a lot of us that are starting to talk, and this is one of the things that I said before. There's some good stuff out there with the folks that are kind of talking about what I call building the evidence or the magic letters, but I really haven't seen any of us that stepped up and held their hand up to talk about litigation, and I'm not sure why that is. I have some suspicion that it's all on what you hear all the time, which is I'm not giving legal advice. I'm giving you guys legal fucking advice. There you go. Sue me. So I don't care. It goes to a new level when I have a POA, which I would love to share that with you too. And this is kind of like the next phase of what I'd like to talk about for a few minutes, and then we'll part ways for the day. But I think there is such an opportunity if you picked up the torch, and I can tell you that firsthand, that there are so few people talking about what we are talking about, that if you truly go through and you learn, it's a skill set that's going to serve you. It's going to serve your family and your legacy for the ends of time. I have 2 pairs of little eyeballs that are looking at me, my grandkids. And I want them to see me not in handcuffs and shackles. I want to see them saying, hey, he moved the needle. You know, and I don't see that out there right now. I don't see it's ripe for. Now, my boy over here, Cam, kind of called me out. I told you the ego earlier, and he's saying he's the best. I already told you I'm the best. The only difference is I don't have the platform. Guess what you're probably going to see in the next 12 months, and I'll shut his cocksucker up, so he won't be up here talking shit. But we're going to do this together. I think it's important that there's no measuring dicks in this game, and we're both in our lanes, and I know if I call him, he's going to help me, and vice versa. I want you guys to take the message from what I just said is it's a fertile ground. It's like virgin territory here right now. There is nobody talking about this, and if you went through and did one time what I've done and did it for yourself and you start talking to other people, you'll find out really quick that you'll replace your annual W-2 in about a matter of minutes. I've had people pay me $89,000. I've had people pay me $80,000. That's not bullshit, and I can show you receipts, and I'm not boasting. I'm telling you that was somebody that could connect the dots to say, I don't want a bar card where I'm 3 notches down. I want this crazy fuck that's going to put me at number 1. So that takes me into power of attorney. Please, if you're going to talk to somebody outside of I know I'm in a friendly atmosphere, so I'm making some pretty bold statements. But if I'm talking outside of this room and we're in any type of official capacity, I've sent you across a POA. You've signed it. You've got it back to me notarized. So now we can talk about the 3 people you have buried in the backyard and all that other shit that I'm not, but I'm truly going to be behind you 100% on whatever we got to do. Now, I'm not going to break any laws. I'm not going to do any crazy nonsense, but I'm never going to fear that the courts are going to come after me with an UPL, unauthorized practice of law. They've tried. They've tried with Brandon. He's had the Bar Association from California write him, hey, I heard you're doing XYZ. He shot it down right away. It wasn't any big deal. But I would never, ever, ever tell you, or I would not do it myself, to where there was not a POA in place if we were in any official capacity together. I think that's super important. I had a guy in Connecticut reach out to me here a couple of weeks ago, $1.5 million house. I'm $100K. And we were connecting dots. And he showed me, and here's what I found the people that are doing. He's 64, I'm 54. He's smarter than I am, and he's got game. He was smart enough to go find a young gal that's doing a lot of she's got a hustle to where she's creating a lot of docs. She's essentially a paralegal. So he brought her on the call after he and I were on it for 3 hours. Her name's Gracie, because he wanted her to hear me speak. I get really passionate really fast, and I'm like, you need to file this 41 fucking E. They're not prosecuting, blah, blah, blah. I'll just go into that, and I go crazy. And 3 hours of my game to him, he wanted her to hear me, and the first thing we talked about was, and he's on the phone, I'm not hiding this, don't you ever fucking create a document for this guy again. I don't care that he's paying you $100 an hour. I could give 2 shits. Don't do it without this. I'm sending it to you right now. And he's like, damn, bro. I was like, well, I don't want anybody doing any of this kind of stuff, because there's already enough traps out there, and they're going to try anything they have. You know, you'll see that in the Branyan v. Experian, if you watch it, just like you do mine, that was me, but you'll see in about the top 6 filings where they're threatening me. Because I filed in. I did that Brandon thing there a while back. So I filed in, and I said they knew, and they said Joey Kimbrough is not to file into this case anymore, kind of thing. He's not an attorney at law, which is all bullshit, and we know that. I just didn't play in the game, and I had the POA, so I'm protected. Tim, you're going to start filing everything in. They know it's me, and there's nothing to do about it. Yeah, what's up?
Real quick, I found case law from before 1873 where there's judges talking about how you absolutely do not need a license to practice law. And then you have case law after 1873 that says you do. And then, I've already shown you that there's only one person domiciled in the District of Columbia. So I think you can put one and one together. The basic element of the license to practice law is U.S. citizens need a license to practice law. State citizens absolutely do not. Period. End of story. Just want to be very clear about that.
So I think the case that he's referencing in the 1800s, I'm pretty sure is Marbury versus Madison. If you do a search on that, I'm almost positive it is. And it talks about the state cannot license a liberty and charge a fee thereby.
No, I found it. Full blown. You don't need a license to do this. You don't need a license to do that. You don't need a license to practice law. Literally, that's how I found a different one. That's literally that fucking clear. It's on my, and by the way, I've been building a lot of case law. So on this subject, he was talking about it earlier. I wanted to say something earlier. When I realized that all my shit had fucked up, false, incorrect case law on it, I almost had like 14 heart attacks. I spent 3 or 4 days just cleaning all the horseshit case law off of the website, off of the documents. It was fucking everywhere. And that was in December of this last year. It was actually pretty recent. And then I read a fuck ton of cases, and I collected a whole bunch of stuff, and I put it all on williamsandwilliamslawfirm.com under the case law research section. Those are all handpicked by me. You're not going to find all those or a lot of those just kind of around randomly on the internet because I found those myself. Some of them you may find, some of them you may not, but you should definitely check those out. But yeah, the whole it's the boogeyman theory. It's like everyone's scared about fucking giving legal advice. It's just complete bullshit. The Bar Association sent me one letter. I responded. They didn't say anything at all. Then they upgraded it to another tier, sent me another letter, cease and desist letter. I literally sent them back a letter. It's like, this has nothing to do with me. Like, I don't know why you're wasting paper. And that was it. It's the last I heard of them. They never called me, nothing. So they just do that because there's a UPL section on their website. And once they send you the first letter and then the second letter, they can list you on their UPL notice list. And that's all they're trying to do. It's complete bullshit. You could just send a letter back, say, I'm not a U.S. citizen, I'm a state citizen of, blah, period, sign it, send it back. You don't even need to do that, but if you wanted to send them something, that's what I would recommend at this point that you send them. That's all the information that they need to know.
I got a question.
Yeah.
So is the power of attorney only available in administrative courts, or is that also available in judicial courts?
No, power of attorney is old as dirt. Power of attorney is old as the English Empire.
Okay, so I say that because if one of my kids gets a traffic ticket, am I able to help them up there at the bar to address their court?
So there's a term called next friend, which you can see in the Constitution. It's called next friend. There's like almost zero fucking information about it anywhere. It's called next friend. I would just put that on there and fucking go for it if you want to go for it. That's what I would do, but I don't know what the fuck that's going to do. But that's the only thing.
In the Seventh Circuit, I saw one where a daughter was working on a dad's estate. And it's like Brandon, right what he was just saying about what California was trying to do to him, that's where I would say that was a perfect point. What he did is he rebutted their horseshit.
Yeah.
If what we typically do is ignore it, myself included, I'll hold my hand up and put myself, you've just, through acquiescence is the technical legal term, you tacitly agreed to what they said. So you are a pink elephant that's operating under the unauthorized practice of law.
So one of the things that I've heard about that, because I want to help my kids with their traffic tickets, was you can go in there as moral support or administrative assistance, standing up next to them in at the bar as they're dealing with the prosecution and judge. So I haven't done that yet. That's something that I plan on doing the next time around. I didn't know if anybody else had any experience with that at all. Power of attorney or helping your.
How old's the kids?
19 and 21.
Okay, so they're above age. So
yeah.
You got a POA, man. Your dad, it probably won't be challenged.
Hold on, 1 second. The 19-year-old would still be an infant.
Yeah.
Straight up, I'm dead ass. The 19-year-old by Black's 4th edition would still be an infant. Did we not just read that? Who'd I just read that with?
Okay, well, all right. So also my wife's case, I kind of. So
hope she's not 19.
No, she's not. No.
need
Do,
to be
do I look
supportive,
that
bro.
old? All right, okay. So my wife went up to, my wife had a case, and I went up there by her side, and she didn't announce that I was there for, moral support or administrative assistance or anything, but the judge was a little bit more lax because I was her husband, and we were discussing, as something would come up, she would just kind of look at me, but he did have a problem with it. But we didn't make any general announcement. So I think it might be different with the husband and wife relationship. So
You're one.
If you have a marriage license, you're the same person in law.
That's right. And under 15 U.S.C. 1692, I believe it's H, you'll see it defined in there that a husband and wife can speak on behalf of one another. So there's statutory reference as well.
That's why the Fifth Amendment applies to married couple.
And the 14th.
Your favorite. my favorite. The fifth is, right against self-incrimination. You speaking about your wife, if you have a marriage license, is like you speaking about yourself. You are considered the same person in law. Now, a lot of you guys probably don't have marriage licenses. You couldn't give me a marriage license with $450 billion and a fucking shotgun. So the thing is that, and that's not because of women or not loving women. It's because I'm not going to have a threesome with the state. Never going to happen because it makes me a resident for the rest of my life. As long as that dumbass fucking piece of shit marriage license is still there. So I wouldn't do it. So I wouldn't be able to act upon like that. But if you did have one, do you have a marriage license?
I do, yeah.
Okay, there you go.
We tried to separate it between, contesting jurisdiction, keeping it in common law or judicially rather than administratively, but they obviously didn't care about that.
I'm going to say something that's really clear. Only Negroes need to have a license to get married. Yeah. It's very clear.
So if you do want some case law, going back to the pro se part or representing yourself, all of that is under the Judiciary Act of 1789, so that goes back a long way. And under the next friend part, they actually define it as the next friend has a significant relationship or legitimate interest in the welfare of the party, and that's from 1990, Whitmore versus Arkansas Supreme Court.
Say that one more time.
Whitmore versus Arkansas.
Whitmore versus Arkansas.
1990.
1990 versus Arkansas.
Thank you.
So there's something I wanted to read here from you. This really gives us some context, and then we'll wrap things up for the day unless there's any other questions. And this is something that I'd love for you guys to look at because this goes back. I'm kind of like Brandon in that regard, looking at this historical stuff. But this came from the context that I'm getting ready to read here, and it's short. It came from Chief Justice Berger's testimony before the Royal Commission. So this is what you should write down if you're going to look for it. The Royal Commission on Legal Services in London on July 22nd of 1977. And I'll read this. And this actually, a friend sent this to me. So here's the quote from him on the record in that official capacity of a legal, this is a Chief Justice of the Supreme Court of the United States. 75 to 90% of American trial lawyers are incompetent, dishonest, or both. Signed, Chief Justice Warren E. Berger before the Royal Commission on Legal Services. That's the top guy in the top court in this country that said that about the whole entire judiciary community. 75 to 90% of them are incompetent and dishonest. That's his words, not mine. So if you do the research as I would, you'll find that's true. And that's why I think it's important. I know the lower levels where most of us wade through, where you're starting out your journey, is a weed out. It's like freshman math at college. It's there because they know you're smoking shit and they're going to weed you out. Look at that as to pro se, that's their weed out class. They literally give you all the bullshit to keep you out. The appellate level is where case law is decided, so they're very much more, they scrutinize whatever's coming across, but that's where the action happens. That's where I believe it's probably the most important court that there is in this country, because that's where law is established. That's where it's upheld. So then you go to the Supreme Court where you have two different decisions, maybe in the Seventh Circuit and the Ninth Circuit, where they're disagreeing, and really that's all that they are doing is just trying to uphold what has already been put into law, saying, hey, Joey has this going on in the Seventh Circuit, was ruled this way. Brandon in the Ninth had the same argument. That's where we all need to start talking, because now that's when we can use the Supreme Court of the United States to help us to say, hey, she didn't get the same decision I did, and we start using that as persuasive authority to help ourselves. So when we start all talking, I think that's the exciting thing for me, is seeing how many people are really interested in this, and having the people that are asking me the questions that I know that they're truly in it, you know. So yeah, if there's anything I can do, man, I've given a lot of people my number and email. I'm pretty accessible anytime. If not, you know, I have 5 buckets, and these 5 buckets are going to sound crazy. I have my cases, which are very active, and there's a lot of them, and I like to go outside of the lines of credit to just test stuff out. I've given you a lot of examples there. There's Brandon's cases that I've slowed down on a lot, but if he calls, I'm there. There's Brandon and Joey sharing clients, and then there's Joey that has clients, and then there's pro bono that I do for friends and family. So there's 5 buckets, which I enjoy a lot of those. Now, a lot of those are not in credit. It's me testing out stuff, and I'll continue testing out stuff, and I hope you guys do the same. But and I know a lot of you guys are looking at the criminal component or whatever it is. I love hearing you're not a litigant if you're not a defendant and a plaintiff. If you haven't been sued and you don't know how to build a case to sue someone else, I'm looking at you like you're in a different gang. You know, I'm not hating on you, but it's still you've got a long ways to go. So there's 2 different things going on there. You need to learn how to, 1, protect yourself and file those 12B6s in a defendant role, and then building that evidence that we talked through a lot today on how to do it effectively, and then kind of managing the cases. Those 4 pillars I told you about before you even get into a case. I mean, I really don't even talk to people until I know they have a really good grasp on those things. Judiciary codes of conduct, professional standards of conduct, rules of evidence, and then the rules of the court, or trial rules. So those 4 buckets right there, I mean, I only lived in one of those buckets and was successful in one of those, and now I have the other 3, the 2.0 version, which has opened my eyes up to like stuff. That's where the presumptions came from and all that conversation. But now the next level is really holding the judiciary accountable, because you can, and they know you can, but none of us ever show them that we can. So I think that's important, to have a really good understanding and a grasp, and the only way it is to kind of look at people that have done it before you, and I hope that's me, that I can help you get the 2 steps farther down the road than maybe you are right now, and then hopefully one of you guys will get me 2 steps further down later on. So it's a great place. It's a great time to be there. We have some tools that are available. Like Cam said, I'm open like that too, man. I use AI to what it's used for, but I know how to prompt it. I know how to ask it to what's going on here, and then we chop it up. Like I said, I'll go out and find the opinion that it says is there, and then I upload it to it, and we start chopping up business. So if you talk to it in the way that it's designed, but if you just say, write me a motion to this, it's not going to give you what you're going to be able to use it for. So there's some stuff that I'm building right now. I was hoping that I could bring to it. It's just not far enough along. It would be a disservice to you right now, but there's some stuff that I got on the horizon that I think you're going to enjoy. It's going to be a dashboard to be able to keep all you. That was the biggest thing for me. And I know it has been for Brandon as well. Where do I keep all this fucking shit? I got clients and folders. If you looked at my desktop, it'd be like, holy shit, how do you keep it all square? And then literally you'll open up any one of those folders and there's hundreds of filings and stuff in there. So getting a system put in place, I think, is where I could serve you guys the best right now, and then creating a knowledge base that already has everything we're talking about built into it, that you could use AI to go talk about real stuff that's going on. So that's kind of just a glimpse of what's going on in the horizon. So
yeah, absolutely. I just don't, if anyone's going to do any of this shit, you're going to be reading. If you don't like to read, you should start changing the fact that you don't like to read and try to make it into I like to read. Maybe have a glass of wine. Maybe smoke a cigar. Maybe go outside. Do something to make it more pleasurable. Because the thing is that if you're trying to, I'm not big on the AI stuff. I'm different. Again, 14th Amendment, we're very different. And the reading part is also very different, right? So the AI part. I don't use AI. I use AI a couple of times to find cases. I've used AI a few times to find cases. And then I stay the fuck away from it. And I probably don't prompt it right. I probably don't ask it the right questions. I feel like a fucking old man when I talk to these two because they're like, you got to say it certain ways and shit. I'm like, get the fuck out of it. Get the fuck off my porch, kids. You know? That's how I feel. I feel like a 100-year-old man. It's like, damn, I never thought I'd see the day when someone tells me something cool technologically and I don't want to fucking hear it because I'm, an old bastard. But here we are. So the thing is you can find cases and then just sit down and read them. You're learning about your government. You're learning about the history of your country. You're learning about some cool shit. People had some cool shit happening, and they're going through it, and they're talking about things. I mean, even that one case I was talking about with qualified immunity. You forgot in 1967, which is right fucking yesterday practically, we had separate bathrooms for whites and blacks. And they were protesting, and we're gonna protest by going and fucking peacefully, kindly. We're gonna drive down to Chattanooga, Tennessee. I'm gonna walk my ass into that whites-only bathroom. Yeah, I'm gonna really show them. And it just fucked up everything by giving cops qualified immunity, right? They had no idea. They're like, this is really gonna cause this? Like, what the fuck is wrong with our judicial system? You see the point? But the thing is, I think I've read 15, 25, 30 cases. Read a case, it takes several hours sometimes for some. Dred Scott versus Sanford's gonna take you like days. It's like reading a whole fucking book, okay? But it's like, okay, you read 15, 20 cases. Read some fucking cases. Like, if you're trying to avoid reading all the time, you're going to be avoiding to read the docket. You're going to be avoiding reading what they're sending you. You should get in the habit of, like, reprogramming your mind. I want to read. I want to know. Maybe not what the bar cards are writing. That's usually pretty awful. But the case law and the history, and you're learning about your country. A lot of you might not even have realized that in 1967 it was this big fucking huge epic thing for a goddamn pastor, a black pastor, to go and fucking rebel against the system by driving down to Chattanooga, Tennessee and fucking using the whites-only bathroom and getting arrested for it. Unfucking believable, right? It just happened. 1967 just happened practically. So the thing is that you read this shit and you're like, damn, like, it makes you feel better about your own life. It makes you feel better. Yeah, this fucking problem with my girlfriend ain't shit, bro. Like, I can't pay this and I can't buy a Lamborghini. Like, that's really not a big fucking deal. Like, you're reading this shit and it's like, it changes your perspective. And it isn't this like boring history thing like what you had in school because it's relative to what you're trying to do. When it becomes relative to what you're trying to do, it isn't just a fucking bullshit history lesson anymore. It's actually really fascinating. So I think the AI stuff is cool, and I think you should use it, but I think being an old man, the old man that I am, I think you youngins should get to reading.
Yeah, I don't disagree with that wholeheartedly, but I like to turn around stuff pretty quick too, and usually whatever you get from the courts or an attorney in that, it's going to be bullshit. So what I typically use it for in that capacity is I'll upload that PDF and I'll say I'm going to respond in opposition, and then I start putting down the facts of what I want to say. That's really a pretty quick prompt, and it'll go to work. And it'll show me kind of where my mind's at with what I've just prompted it with. I love doing that. It's the way I call it chopping it up. So there's going to be differences in how we use it, but just the volume of what I do and what comes at me, it's a good first cut. I love reading opinions and stuff too. It's an awesome place to start. But I'm also there's going to be a lot of things that we do a lot different. I'm also going to use 42 U.S.C. 1983. Whether that's the 1/8 in me that's coming out. And the reason why would you say that you're going to use that still if it's bullshit, as Brandon said? And it's not that I disagree with him, because I do actually agree with him. I'm going to use it because they still are using it. Cops are being sued every day in this country, and that is the cause of action that's being used is under color of law, and it's always 42 U.S.C. 1983, and they're all being sued for that with monetary compensation behind it. So I get the argument, and I get where it's coming from, but until they stop, this is where I would say Uncle Joey said FCRA is the best thing in the world, and everybody should have an 800 credit score. And I truly believe that. And if you don't believe me, then we can't jam, because that is true. But the thing, you know, here's where Brandon might disagree with that, and rightfully so. It's been around since 1970. So I've been around since 1970. July 19th, if you guys ever want to send me a birthday card, 1970. So I've not went away in 54 years. I don't think the FCRA is going to go anywhere anytime soon, but if it got rewritten for whatever reason, I think it's only going to change for the better for us, because that's one thing I've seen Congress has done right. So I can stand up here in front of you and say, if you don't have an 800 credit score, there's only one person that's responsible for that, and shame on you, because all of the tools are in place. You have a guy here that's done it 45 times. Using that statute, that one only, and I just walked you through exactly how I did it, how I talked to the attorneys, and I would love to talk to you about that even further if you get down there. If you get to the place where I was, you'll see how excited I get when you call and say, hey bro, I'm going into a negotiating conference tomorrow, I'm scared shitless, what's up? I want to be there with you. Somehow tag me in, man. I want to sit there. I'll sit and mute, I promise. I won't say a word, but man, I'm going to be texting you. So say this, bro. So that's what I did for my buddy Tim. I made the judge fall in love with a decorated war veteran. I knew exactly how to push the buttons. Mr. Banyan, were you discharged? Yes, sir, I was. What service? Air Force. Two tours? Yes, Silver Stars. These attorneys were hearing this shit that I was crafting behind the scenes while I'm on mute, and the phones were ringing thereafter. We had 3 people, I believe it was, that settled right after that phone call where they were having a love fest, my buddy and the judge. So it's real. I'm telling you, I can stand up here until you go through it yourself. It's real. I would love to tell you you're going to file magic letters and stuff's going to go away. Not going to happen. There's plenty other examples I have of building evidence, and we can maybe go through those tomorrow. As far as body cam, I talked to Sonny about that earlier. I don't think he realized that I would get him there, on a call. Because here's what you're going to see, I'll just leave it at this. Is a lot of times if you try to tag the cops in where body cam is associated, they're going to tell you right away, this is not a criminal matter, it's a civil matter. That's bullshit. So I'll write up something making sure that it's a criminal matter, and then when I don't call 911 because it would be on a police blotter on Facebook and everybody would be talking shit about me. I'll usually call the after hours number that's non-emergency so that it's not hitting the rolls of Facebook. So I'll call them, and then there's a cause number associated with it, and I want the body cam. Want the body cam, man. So when the cop shows up, Andrew Brooks, I have a call number there, and he's got it on, and now I've got that there. So I do things like that. I know how to build the evidence, and that is the single most effective thing you're ever going to do is bring the energy down, think through it, and say, okay, here's how I'm going to put this on the record. Because I'm always thinking about how am I going to get it on the record? How am I going to get this on the record, what it is I'm saying? So anyway, I'll leave you guys with that. If there's no other, you got a question? Okay.
Hold on, Papa. I've been helping some friends and family with some of their court cases, and I'm familiar with the next friend doctrine, and I realize I need to get POAs with all of them. But my question is, what about attorney in fact? I've heard about it. Can you explain a little bit about what that term means?
The power of attorney and attorney in fact are the exact same thing.
Okay, great. Thank you.
Yeah, and you'll see the statutory reference. So for me in Indiana, take out that keyword, put in yours. It's Indiana Code 30-5. Know it like the back of my hand, and it tells me all the authority that I have and the fact that I have to act on your behalf as a fiduciary. It's all spelled out there. But it clearly says that a power of attorney in Indiana or wherever you're at is an attorney in fact. It's one and the same. So don't get confused by that. Yeah, man.
The only definition I've ever seen myself for practicing, because I looked for it for a while, actually. I finally found one. It's like 8 CFR 1.2. It's like a really random spot. I found it. And it's basically making an appearance on behalf of somebody else. An appearance is defined as filing in on someone's behalf and speaking for them because they essentially can't or won't. And if you're a witness in a case, you are not technically appearing in a case, because an appearance is you're on behalf of a plaintiff or defendant. So an attorney in fact is somebody, essentially, in a more technical sense, an attorney in fact is somebody who is helping somebody else, but they are not appearing on behalf of a plaintiff or defendant in the actual public judicial procedure, such as a hearing, such as docket items, etc. So, for example, on one of our cases, they said I was practicing law without a license because I was sending some letters privately on behalf of one of my clients. That's complete bullshit, in my opinion. But anyways, that's what I dug up off that.
I would say, too, back to those 4 pillars that I keep referring to, the rules, that when you get into the civil rules of procedure, just be careful with that thought process right there about the appearance specifically. So in Indiana, Rule 3.1 clearly will tell you what an appearance is and who has to file it, and it's both parties. And it tells you it has to be according to the Indiana Office of Judiciary, assignment or whatever they're called. So, which is the Supreme Court. just read those, man. I can't state that enough, is read like the first few rules that tell you how the timing is in Rule 6, 7's telling you what are pleadings. But Rule 3 will tell you 100% whatever state you're in, what appearances look like, who is to appear, how do you appear, and all of that other. So I write an appearance in everything I do in state court. I file an appearance, and then I file my summons, and then I file my complaint. That's a little bit different than what I told you I do over in federal court. So just study those first few rules right there in your state and just see exactly what it is, because all of them are different. It's just like all of us are different. The rules are pretty much the same, and I could tell you exactly what your states, for the most part, say. But there's going to be enough of a deviation, and you get in federal court, and I don't want to. You already got it. I just hit you with a fire hose. But also, when you get into federal court, look at local rules. And I don't know if we've talked about that before, but that's one that'll truly get you tripped up real fast. And this is all designed, by the way, to throw you off if you want to go down the path. You're in Southern District where I'm at, you have the federal rules of civil procedure, but you also have local rules. And when it comes to motion practices and stuff, that becomes very important. So just be very careful and cautious. And man, if you go in, here's where Brandon and I are 100% read. I read those rules. I read that procedure like he reads everything else, and that's where we come together and we do some cool stuff. So you have to read something if you're getting the case. My preference, if I were starting you out, would be get a good grasp on those 4 pillars I was talking about. Know what the judges are supposed to do, know what the attorneys and how they're supposed to act, look at the rules, and then look at the rules of evidence. And if you do those things right there, man, you cannot be beat with what I told you earlier, man. There is no way I could ever buy into you being beat if you truly went in and you presented yourself knowing those 4 pillars. And there's not a lot there, honestly. If you spent Saturday and Sunday having a couple of beers and sitting down and you do 2 each day, and you would pretty well know it. And you'll keep going back. As a case becomes live and you get into stuff, you'll keep, hey, man, I think Rule 15A is the one that told me about leave. And it is. That's where you'll find, your leave to amend any of your filings, your complaint in particular. It's a motion to leave pursuant to Rule 15A. So you need to, there's where I'm really good at prompting that stuff, and I know Cam is too, is to know exactly where to go into the rules. And if not, that's where you can ask AI and stuff like that, so you can have a real cool chop-up session. But yeah, you guys, any more questions, man, or just call me offline if we're wanting to get out of here. That's cool too. But
real quick on that one, most attorneys do their whole career, and what he just explained is all they know. They don't know a fucking thing about the law. They don't know what a person is, and they don't care. Just to be clear, like if you want to win cases, what I do is not anywhere near as important as what Joey's talking about. I love what I do. I'll lose for the next 40 years. I'll be the happiest pig in shit. But the thing is, if you want to win cases, again, I'm just going to tell it like it is. What Joey's talking about is where it's going to happen. Sadly. It's fucked and it's gay and it's fucked and it pisses me off every fucking day that it's the fucking truth. And I literally not gonna say things of what I want to fucking, how angry it makes me. I think the court should be someplace where we can all come together and have cool talks and talk about real things and philosophy and real fucking issues, and it should be a place where people can come and voice their concerns, not this procedural piece of shit fucking nightmare. But this is the world we're in, so.
Just to finish that up, I mean, you just heard the Chief Judge say 75 to 90% of exactly what Brandon just told you right there. He's telling you the same thing. They're incompetent, and that is true. I found that. And I'm not saying that I'm smarter than them, because I'm not. I've taken the LSAT and all that other shit, but I'm telling you they do not even know, and then they'll do the presumption game on you, and yeah, what's up? And most of us don't rebut it.
Oftentimes I hear people referencing Black's Law 4th edition, but my research indicates that the court systems in the United States go off of the most recent version of Black's Law, which is the 11th edition. I own the 11th edition, and the differences in the definitions between 11 and 4 are significant, and I just kind of wanted your feedback, 2 cents, your take on that.
I use the 8th. You know, I spent $360, and it's probably, as you know, the biggest book you probably own in it's huge.
And I'll say this too. You ever heard of the whole act rule? Whole act rule. No. Okay, that's a doctrine. Whole act rule. The whole act rule will allow you to go all the way back to the very original legislative writing. You have to invoke it. You have to invoke it. We use that a lot in conjunction with the rule of lenity because, see, the prosecution likes to go outside of the definition all the time to try and make it fit. You know, sometimes it'll be like you have and within the definition, and then sometimes you have or. Well, or is either or, right? And is very specific. Sometimes they like to use that and as an or. No, that ain't gonna happen. So when we invoke both doctrines, rule of lenity and the whole act rule, that allows us to take the legislation all the way back to its original creation, because they be changing that shit all the way up, right? So that's how we get around it. You're welcome.
I've never actually seen that. I've never seen that as a problem at all. And the thing is it's I've never seen anybody really bring that up. I've never even seen a fucking bar card bring that shit up. So you got to think, the biggest pieces of shit walking the earth aren't even bringing that up. So if they're not bringing it up, you ain't got nothing to worry about. And also presumptions. It still just comes down to presumption. I could presume that a fucking car is a purple people eater, and if you don't say it's not, fuck you, it is.
I would encourage you, because you're bringing your law to the court, to do what they do. You roll like they do. Give them the terms and definitions. Yep. You bring yours. And so if you're bringing it from the 4th or the 11th or whatever you want to do to your best advantage, you're bringing the law in your document. You choose the language. Yep.
When you do that, you're the one setting the presumption, and now what does 301 say? You set the presumption, and then those dumb motherfuckers have to prove that it's not. Fuck them.
Rebut that shit.
Rebut that shit.
They've got to bring the evidence is the key word. I meant to mention that when Brandon had that was the most important thing that he read in that presumption paragraph there, evidence. They've got to bring evidence forward to rebut your claims. So that's the key, and then you as you progress in your journey, when you start reading 402 and 3 and that same rules of evidence, that's where it'll talk to you about what admissibility is and what irrelevant evidence is, which is all of their horseshit. Admissibility says that it has to be done, especially when you go to 603, which is where Brandon talks about it has to be done under affirmation or oath. So when you start reading all that shit, you're going to become enlightened, and you're going to be, holy fuck, they're playing mind games. It's just everything they're doing is horseshit. And it's not, and here's where I don't hate on them so much. They're playing a game, they're giving you the rules, and you're not, it's like me beating you up on Monopoly and I'm hiding the rules from you, which I did to my kids, by the way. So I know where they're at and what they're doing, because my ego made me beat my kids. I couldn't let them win. They're not going to let you win, and they gave you all the fucking rules, whereas I didn't do that with my kids. So how does that make us look? That's why they look and they say, another fucking pro say, here we go, this is going to be easy. I've even heard them say that, by the way. You know, I've heard them say things like, yeah, we should get this one thrown out pretty quick. I've had attorneys, in my buddy Tim's case, JP Morgan Chase, these are the same fucks that let Bernie Madoff do all the shit to this country. These guys are on the phone making $1,050 an hour. I know that because she let it slip. And she said, Mr. Brannion, if you'll take $1,500, that'll be cheaper than what it'll cost my client to write up a motion to dismiss here. That was her being arrogant. That's okay. I'm not hating on her for that. We made $1,500 because we agreed to it. He got all the shit off of his report. So if you know how to play that system with them right there, they're there to help you if they can. But like Brandon said earlier, they do not know a fraction of what you're going to know if you just study the 4 pillars that I talked about earlier in 1 or 2 cases in your area. Look at bankruptcy cases if that's what you're interested in. I'm not telling you one way or another. I'm telling you what I could do if you went that route, and I've done that. I'm not telling you about credit stuff. Do whatever you want to do, but look at a few cases like I did. Steal the shit, plug your stuff in, and it's you've got it. And then from there, man, you literally have set up the legacy not only for yourself, as Brandon alluded to, and I think correctly so, infinite money, a new way to do it. I think through that, I think he's right. Just where I see the possibilities right there. But you also have the ability now to teach your entire family, friends, or everybody else that's looking at you like you're nuts right now when you start talking about this, talking about a guy with a pickle suit and bleached assholes. I mean, like I did. So I don't know. Take it where you want to take it. I'm just telling you it's really excited, man, and I'll kind of leave it at that. So if you guys want to talk, tap in, that's cool, whatever. But yeah, we'll take off, I guess, for the evenings, right?
Just a little bit of an announcement. But first off, everybody give a round of applause for Joey.
Thank you. Thank you. Thank you.